Serial number 78, my lords.
78.
78, my lords. I am for the respondent accused, my lords. That's it. The advocate for the complainant is also present, my lord. Also present. Both the parties have agreed for mediation, my lords. The matter to be settled in the mediation. And
Learned advocates for both the sides. Submitted that the parties were agreed for
that's advocate for counsel is
mediation
complainant is
process
also present, my lord.
for resolution of the disputes. Therefore, learned counsel requested the court to refer the matter to the High Court Mediation Center.
My lords,
Only thing is in this particular matter, that the senior mediator be appointed to S. Sushila matter, if possible.
Pardon?
We request the appointment of Ms. S. Sushila as senior.
designated senior counsel,
mediator,
madam.
because the parties have both jointly consulted. It can be sent to the Bangalore Mediation Center, sent to the coordinator may appoint. Because it's a matter of child custody, and in this for several 2.5, 3 years, there was no access. And thereafter, after the intervention of the Honorable High Court, access started happening. And we want to resolve this matter after great difficulty. Both the parties have agreed for a mediation. One person stays in Bombay, the other person stays in Bangalore. So we would request VC facility also if required.
We have taken the consent of Sushila Devi, madam.
Yes, sir.
In that view, the refer to the High Court meeting by the registrar. At this stage, learned advocates for the party stated that they have actually agreed to have a mediator.
Yes.
Full stop. Is open for the parties to make a joint application to suggest to the mediation center the name of mediator jointly selected by them. If such application is made, the High Court Mediation Center shall consider it favorable.
Lordships can.
Yes, Mr.
I'm moving a memo for 2 appeals, my lords. These are appeals under Section 9 of the Arbitration Act. My property is languishing. There is some urgency.
I'm moving a memo, my lord, for a
Date before then the parties have to go to the mediation center and date before the court.
The procedural at the High Court Mediation is not intimating to the board's date.
Sorry, Doctor.
The mediation center shall intimate the parties about the date
Let's,
once the matter is referred to the arbitration.
if any date is being fixed, my lords, request for a date after
That will
11th
do
of
by
December.
mediation center, not
Yes,
by
my lord. Yes, my lord. Grateful, my
I'm
lord.
so grateful, Doctor.
Grateful, my lord.
My lords, my property is languishing. This is a Section 37s against an order under Section 9. my
5th
lords.
December.
Lords,
This is a contempt matter where respondent has been directed to pay a sum of 4 crore rupees in 18/4. Where the petitioners are senior citizens, they are in need of dire financial difficulty, hence the matter may be heard.
December 9.
December.
Let's, item serial number 101, madam.
101. What is it?
Is a matter pertaining to the tender issued by the Western Naval Command, lords. Matter pertaining to the tender issued by the Western Naval Command, madam. There was a fraud committed by the unofficial respondent in favoring the tender. Lordship directed to be listed today and for the hearing the matter today. I request my lords may kindly take it up at 2:30, my lords. My lords, the urgency is this, my lords. Without issuing the work orders, the work is started and they are going to finish the work tomorrow and work orders being issued tomorrow only. If that's so, the whole tender process will be at week
We'll see.
and the writ petition will be infectious, my lords. That's the only request.
Let us see where we reach at 2:30.
So this is a review petition, filed on writ petition. If the
No urgency in review petition. You remove the office of petition and then you will list it.
we have filed the application. We have filed the application.
It will list it then. There is no question of sending memo.
I'm going to withdrawing on matter. List number 2, serial number 1. I'm going to withdraw that matter.
1070.
Yes, no,
1070.
no, not 1070.
List number 2.
On list number two, serial number one.
List number two.
771 of
1107.
Yes.
Proceeding number
771 of 2024. 771. List number
seven.
two, serial
So
number
that is
one.
serial number three. Number three in the second board. Learned Director Mr. Kiran Kumar DK files a memo dated so and so, which is taken on the record, seeking permission to withdraw the contempt proceedings. As not pressed, dismissed as withdrawn. Which matter you are withdrawing, right?
List number two, serial number.
Same. Any. Any. I don't have draft. This is. Well, this is so, this is today. This is that one. Sorry. This number two. Yes. List number two, serial number one.
Lordship's kind permission, my lord. One commercial appeal has been filed, my lord, and by misrepresenting an interim order has been taken. Under order 7 rule 10, my lord, he can't even file a commercial appeal, my lord. He is protracting the proceedings of an eviction suit of a senior citizen. They're stopping the rents, my lord. There almost more than 2 crore rents has to be paid, my lord. He's taken a stay here, which is not maintainable, my lord. On maintainability, this honorable court has kept it open and granted a stay of proceedings, my lord. The urgency is both are senior citizens. Their mother is in hospital. They need the money, my lord. Because of this stay, the eviction suit is not proceeding further, my lord.
9th December.
My lord, already 2nd December is the date, my lord. That is why I'm moving. 2nd December, already the date is there, my lord.
2nd December.
Lordship filing for memo, lordship. Contempt memo, lordship.
What do you want?
Sir, lordship,
What do you want?
filing for contempt memo. Contempt memo, contempt, lordship.
For what?
Cognizance, contempt committed by respondents or accused, lordship.
So file contempt petition. Where is the question of tendering? File contempt petition.
Lordship,
File contempt petition.
yes, lordship.
File it, yes. Yes, ma'am.
Serial number 22, list 1, my lords. I appear for petitioner in this case.
I
There's a
appear for the respondent, my lords. They have already,
22, what do you want?
short accommodation.
22.
we have no objection, my lords, but a date may kindly be fixed, my lords.
4th December.
Please, my lords.
At the request of learned advocate Miss Maitreyi Krishna
Krishna.
for the appellant.
Yes, ma'am.
Please, my lords.
26, list one.
Pardon?
Serial number 26,
26, yes.
list one. I appear for the appellant. For 2 weeks. Time.
2 weeks, 11th December.
Yes.
Stand over to 11th December as requested by learned advocate for the appellant.
Any mention through VC, sir? List number 1, the contempt matters, still number 1.
Notice
Hamid Xavier,
returnable. Notice returnable on 17th January.
still number 2.
Same.
That's serial number 2. There's a writ appeal in 1318 of 2024. This may be connected along with that, my lord. Both may be taken up.
Notice same. On that day will.
It is listed on 6th of January, my lord. Same date may be granted.
Next. 17th January. Notice.
Still number 3,
Same. Notice.
still number 4,
Same notice. Same date.
still number 5,
Same.
Ali Shantappa.
Complainant Manga.
Same. Complied with. Complied with. It is complied with. Order. Notice written on 17th January.
Still number 6, CH Maltesh.
Same.
Six may be, serial number 6 may be premature, my lord. Serial number 6, 4 months has been granted for compliance. The order is dated 23rd July, my lord. That has not expired. There is no cause of action as set as on today, my lord. Premature, appears to be premature. The order is dated 23rd July 24.
That's right. No, then it is 4 months is over, not over.
Four months' time has been granted, my lord, from 23rd July 24.
The order which is, the directions and the order which are sought to be made subject matter of contempt petition sought to be complied with within 4 months from the date of the receipt of the order. The order of law and single judge is dated 23rd July 2024. Therefore, considering the date of the order itself, much less the service of the date of order, the period of 4 months granted for compliance has not come to an end. In that view, the contempt petition is premature. It is dismissed on that ground alone. Nothing.
Seven.
Everything is come.
7, 8, 9, 10.
Pardon?
7, 8, 9.
They are within time.
Same. Why were then cost? Why were?
No, my lord. They are within time, my lord. They are within time, my lord. Cause of action is there. They are not premature.
They are within.
I'll
time.
take notice.
All other. This is which? This was 6 is dismissed. 7, 8, 9 all notice, same, 17th.
Still number 11.
Respond in this case, my lord.
TPK.
What about 10?
10 is same, my lord.
Same,
Notice.
notice, 10 also same, notice written. 17th Jan.
Number 11.
Respond in this case, my lord.
Yes.
Would you like to submit? Lord, in this case, I would like to bring to your attention page number 67.
Where is the trial court direction?
Lord, page 32.
68,
Page 32.
Page 32 of the-
trial court, sir.
File code page number 67.
67.
Page number 106, my lord. 106, appointment of commissioner.
Page number 67 is the interim order of the trial court, which was ordered to be complied by the learned single judge.
My lord, in this case, the complainant filed a writ petition challenging the appointment of commissioner. An observation was made in the writ petition asking us to directing us to comply with the order. I completely agree. My lord, on page number 67, I would like to bring to your attention IA number 3, operative portion of IA number 3. IA number 3 filed by the plaintiff under order 39 rule 1 and 2 is hereby allowed. Accordingly, defendants or anybody claiming under them are hereby directed to host back the plaintiff's website from the defendant server to plaintiff server till the disposal of the suit, with the condition that the plaintiff shall pay the admitted amount due to the defendants for the respective invoices or dues claimed by defendant.
My lord.
But I would like to clarify here.
Crux of the issue is this, my lord. There is an interim order passed in a suit that was filed by me, directing the defendant to host my website, which is at this server to my server. Now, the defendant, time and again, even to this date, in the affidavit filed in this contempt petition also, claims that the source code is his and he will not give me the website with the source code, and he is handing out my web magazine in a pen drive to the lower court, even till this date. As early as last week, again a pen drive has been given to me stating that it
Milord,
is compliance of the
Milord,
order.
Milord, I would like to clarify. How will I transfer the website if there is no access given to me to the?
You're not understood.
Sorry, Milord.
So you're,
Apologies, Milord.
yes.
If I may, I'll go from the top.
No, this petition was filed for what?
Petition was filed for mandatory injunction against the defendant. This writ petition was filed by me challenging the order of the lower court allowing an appointment of in the trial court was dismissed. As in the appointment of commissioner was upheld. However, a direction was given to the respondents to comply with the trial court's interim order. Since the respondents have not challenged the same till date, it has attained finality. It is on that direction which I am on contempt before this honorable court, Milord.
Commissioner is appointed.
Yes, Milord. Commissioner was appointed. Commissioner has given an interim report wherein he was asking me to share my root password to everybody, including the plaintiff in this case, which I refused. In the email communication which I gave to the commissioner, I said, why don't we meet somewhere? I will hand over the documents to you, is what I've said, which is on record, which is before this honorable court. Please, I would like to bring to your attention. There's an email communication between the parties. Page 131.
So according to you, what is the contempt? If the report is already submitted.
Milord, that's not a report, Milord. The affidavit that they have submitted is they're admitting contempt and they're just justifying that it is not
No,
deliberate.
Milord.
Please,
Milord,
Milord, may please
interpreting
have the
statements.
filed by the other side, para number 3.
So this secure socket layer certificate is activated.
Milord, we are willing to give it to them everything. Milord, my only submission is page number 67 of the petition, of the operating portion of the order, wherein it says the plaintiff is required to pay the admitted amounts or for the dues claimed by the defendants. Milord, in page number 106, the learned trial court says this: according to the expert suggested by the parties will be appointed as a court commissioner to do the acts as stated in IA number 13 as per the memo of instructions filed by the parties. IA number 13 is an application that I have filed at page 98. The commissioner was not appointed only to transfer the website back to the plaintiff server. A lot of things are mentioned over there. Milord, my submission before trial court. That is not a separate matter of this contempt petition. Milord, the problem here is that the commissioner is required to look into the server of the plaintiff and do these acts, which she is not allowing us to do. And Milord, whereas I have paid myself, I've said I will give you access to my my server, provided that you come and have a look at it in my office or wherever in a mutually agreeable place, but not, I will not share my root passport anywhere else because there is confidential data belonging to other people as well.
the details in my operation. Please agree before the testing, you have admitted certain due to the amount that you have to pay.
My lords,
What amount you
been done.
My lord?
My lord,
what amount you are supposed to pay to?
that has already been paid.
No, my lord.
Let me, my
There's a,
lord,
there's a dispute, my lord.
What is that amount? Towards what?
towards the services of maintaining my website.
No,
Where
my
is
lord. No, my lord.
part of the direction?
It is not.
My lord, it is there, my lord. 67, it is there.
My lord, may I request my lords to please have page number 96 of my complaint?
Is it admitted? What is admitted? In another question.
That he will not give me the source code.
That's the subject matter of a counterclaim, my lord. I'm claiming ownership to the source code in the trial court.
The contempt.
No, my lord.
Amount, if my lords direct, I'm willing to pay. However, it is already paid. If my lords direct, I'm willing to pay under protest. But even after payment, it is the contention of the accused that he will not give the source code.
My lord.
My lords, may please have page number 9.
My lord, when I filed a counterclaim before the trial
Why
court,
do you require the source code? You will open the website.
we'll give the website to her, my lord. All I'm asking is, my lord, my lord, I have even suggested. My lord, no, my lord.
Page number 96 of my complaint. This is a objection. My lords, please have page number 96 of the complaint.
My lord, does she
This
want
is
the source code or the website, my lord? That's a
My-
contention. Sorry, apologies. Please continue, ma'am.
Page number 96 of my complaint, my lord, is the objection filed by the defendant to my memo of compliance filed in the trial court. My lord, may please have para number 9. My lords have it. In their memo, the plaintiff asked the defendants to host back the website in the same state as it was on May 26, 2021. However, defendants would like to clarify that as per Honorable Court's order,
This is your,
the status quo of the,
your reply,
I'm pleased.
your reply.
No,
No,
that's
this is-
mine.
Your
That's
reply.
mine.
However, defendants, that is the accused, would like to clarify that as per Honorable Court's order, the status quo of the source code has to be maintained, which means defendants cannot and shall not host back the source code of the website as it is the subject matter of the counterclaim. Even if my lords direct me to pay that amount as he is claiming, this will be their reply again. They will not give
No,
me
my
the
lord.
source code.
That is not true, my lord.
The crux of this entire contempt petition is this, my lord.
No,
They
no, my lord.
refuse to give me the source code and host my website.
My lord,
It-
okay.
Parallelly, if my
I
lords.
would like to clarify, my lord, because a lot of things are being said against me. At page number 60. Yes, ma'am. 1 second. Yes, please. No, because you are making statements which are completely untrue. My lord, at page number 67, the court only says host back the website. It does not specifically state host back the source code. My lord, there are two parts to this website. One is the UI user interface, other one is the object code, which is the publishing engine. My lord, there is no contract between the plaintiff and the defendant for developing this source code. I did it on my own. According to section 17 of the Copyright Act, this is mine. That is the subject matter of the trial before trial court. My lord, it cannot be said that hosting back the website also requires source code. A website will run on the object code. We are even going to test it. My lord,
Vaccine to be published in that website.
My lords, even at para 32 of the trial.
You want activation of your secure socket layer certificate.
Please, my lord.
You want activation of the certificate.
I want my web magazine to be up on the website
Correct.
along with the source code, the entire,
we're willing to give, my lord.
along with the source code, my lords.
No,
along
my lord.
with the-
Why?
Source code is a subject matter of trial, my lord. That's a counterclaim is there.
Why
If I-
source code?
My lord, without the source code, for me to conduct every Thursday, I give updates on my website. There are multiple people working on the web magazine together to upload their articles, etc. All of that cannot be done without the source code.
My lord, let me explain, my lord.
My lord, there is a direction.
My lord, source code
against
is
me
written in English. Object code is in binary language. They will copy it and they will sell it. That is my apprehension, which is what is IA number 9 passed in my
Leave
favor.
Undertaking
No, we have
I'll
given
give
it,
an
but
affidavit that
no, my
there
lord.
will be no.
My lord, page number
Direct
106.
Trial court asking me
Milord,
not to do
Milord,
anything with
page
the
number
source.
106, my lord. Page number 106, in the order appointing the commissioner, the learned trial judge says this. As such, even if the commissioner is appointed, no prejudice will be caused to defendant, and certainly there will be some records between the parties regarding transfer website. With regards to source code, the court says it is a matter of trial. If at all the plaintiff claims that she is the owner, she can have it. My lord, at page 106, paragraph number 7. My lord, just one statement, my lord. The court says this: if the plaintiff proves that she is the owner of the source code, certainly she can get the same after a full-fledged trial of the suit. That is what the trial court says. That has not been challenged by the plaintiff. Now she wants me to hand over my intellectual property, which is what I fundamentally am against.
My lords, para 32 of the trial court order, para 32 at page number 61, my lords. Even according to defendant number 2, there is no specific agreement between plaintiff and defendant regarding the copyright or source code as claimed in para 9 of the written statement. Even this fact at this juncture shows prima facie plaintiff is the owner of the source code of her website. My website is running from 2008. Defendant has come into picture only in 2014. How can he claim the ownership of the entire source code from 2008 to 14?
My lord, this is a
Which is
matter
why
of
there was a
trial.
tri-
It's a matter.
Excuse
There
me,
are
my
too
lord,
many.
this is
There
a
are too
matter
many.
of trial. Let the defendant host
My
my
lord.
web magazine along with the source
No,
code.
my lord.
And I am under direction of the trial court not to do anything with the source code, which
My
I
lord.
will abide by.
My lord, the question here is, has she paid the amounts that I've claimed? She is not paid. My lord, there are two aspects, my lord. Before the cause of action arose, the plaintiff was supposed to pay some invoices that were due. She paid that later. Now she claims that is the admitted amount that she is paying. My lord, my invoices are from July 2021 till 2023 April or May. That runs to about 4.5 lakh rupees, my lord. She is not willing to pay for hosting the website for that period of time when, although it was on my server, the website was still pending. She files my lord, there are too many complications which is not relevant to this case. I don't want to waste your lordship's time. My lord, I will just want to once again state IA number 3. My lord, IA number 9. IA number 9, the court says, IA number for different under order rules 39 rule 1 and 2 is hereby allowed according to the plaintiff and or anybody claiming under her are hereby restrained from saying the source code. My lord, one page before, 66, at paragraph 40, the learned trial court says this. In the page 66, paragraph 40.
For orders.
My lord,
For orders, day after tomorrow.
day after tomorrow. My lord, before, I just would like to point out just paragraph number 40.
Your number?
Paragraph number, page number 66, paragraph number 40.
Yes.
In the case on hand, defendant number 2 specifically made out a case that he has written source code for running or functioning of the plaintiff's website. The defendant number 2 specifically claimed ownership over the said source code. Whatever the decisions relied by the parties, both parties, there is no finding on the direct point on the source code about copyright. As such, it is just necessary to maintain status quo of the source code. My lord, on one hand, the trial court says, prima facie, it appears that the source code belongs to her. On the other hand, the trial court itself says, because there are no case laws. It's a very peculiar case where the source code has been written by me when there is no agreement between me and the plaintiff. My lord, I would like to read section 70 of the Copyrights Act. Section 17. Lord, it speaks about the first owner of copyright. Subject to the provisions of the Act, the author of the work shall be the first. It means to say, if there is no agreement, the author. Lord, the proviso it says, in the case of literary, dramatic, or artistic work made by the author in the course of his employment by the proprietor of a newspaper, magazine, or similar periodical under a contract of service or apprenticeship for the purpose of publication in the newspaper, magazine, or similar, the said proprietor shall, in the absence of an agreement to the contrary. My lord, I was a consultant. There was no agreement between the plaintiff and me. Whatever website was written in 2008 and whatever is existing right now, it's undergone a lot of change. Every single code that I'm writing is my own. She has not paid for the code. My lord, object code is in binary in 10101 language. Source code is in English language. My lord, intellectual property can be altered and the patents can be taken over by the person who is making a required amount of changes to a particular intellectual property. My concern, my lord, is that
So number one, page 67. You
My lord.
refrain from tampering with the website.
yes, my lord,
Number two, directed to host back the plaintiff's website.
along with the payment,
That's right.
yes,
Number three,
not to
is
sell for
telling
me.
the source code.
That is in my name.
So because there is a dispute about source. code.
Yes, my lord.
And lastly, the to directed to activate the secure stock layer certificate.
Yes, my lord.
Now, all these compliances can be done in absence of the plaintiff or not?
My lord, my lord,
No. Without involving him, this you can comply with this direction or not?
my lord,
Activating website, not to
my
transfer.
lord, wait,
the-
to activate the website, it is just to host back to her server. How will I host it back?
So both have to go.
Yes,
My lords, insofar as payment, disputed payments, that my lords posed a question. Facts are little necessary. Plaintiff in 2021, the web magazine was in the plaintiff's server, my lord. Defendant took away the web magazine and hosted it in his server. Plaintiff was supposed to pay for her server. Defendant is supposed to pay for his server. Without the authorization of the plaintiff, defendant took the website, however disputed, it took the website into his server. Now he is claiming for costs of maintaining my website in his server. The costs are not before the initiation of the suit, my lord. That is already paid. Be that as it may, even the payment, I have filed a memo of compliance stating that I have already paid him and I've given detailed invoices of payments being made for which objections are filed by the defendant. After full hearing, the trial court has allowed my memo.
no, my lord,
And that has not been challenged.
my lord.
It is only after filing of this contempt petition, defendant is seeking for clarification of that order
Lord,
in the lower.
Page number 105, my lord. My lords,
The interim order of the trial court.
my lord,
The order at page 68 is interim order.
interim order, my lord.
So for orders.
Much obliged, my lord. Day after tomorrow, my lord. Much obliged.
Oblige.
Say your respective ID. Posting and cooperate each other in.
Bill number 12.
Like to appear on behalf of the amicus, my lords. He's on his legs for the matter before the
I
Supreme.
appear.
Appear for the petition in the matter.
This is the 12 is the same matter?
Yes, your lord.
Yes, yes, ma'am. The learned advocate general may not had made a submission on the last date.
Yes.
Your
So this
lordship
is
may
only
not have
for,
had.
only for orders. Now, this,
Yeah.
this, 3339 was disposed of.
Yes.
Yes, my lord.
And why-
3339, my
why-
lord.
Yes, 3339 was disposed of
Yes, my lord.
by our order, different bench.
Yes.
Then what was the-
2424.
What was the occasion to file IA?
My lord, in that case, my lord, the honorable court, my lord, passed certain orders relating to blasting cases. So, my lord, the persons who were not doing any blasting activity, they moved applications.
Don't change the sequence. No, I had read it, I had kept it in sequence. Very for. Where is the order? Yes, so this order, 2nd April 24.
Yes.
Jurisdictional respondent shall issue mineral dispatch permit. So and so, so and so, so and so. Petitioners shall remove the staked blocks. So what was that petition for originally? Now, can you file IA in the dispose of petition? That is the only. IA for clarification and dispose of petition. Or you have to file a separate thing itself. This prayer in the IA is separate in itself. Mr. Nagananda.
Yes, yes, my lord. My lord, what I'm submitting, my lord, in this case, what happened was the
We are not hearing, listening, we are not able to get your voice somehow.
Lord, in this
Wo-
matter, my
am
lord,
I audible?
There is some interruption in the
Right.
voice.
in this matter, my lord, the direction was to approach the dam safety committee, my lord. In line with the previous orders, your lordship had disposed of 3339, directing the petitioners to approach the dam safety committee.
Where is that? If that is so, then it is all right.
Yes, my lord. I filed a direction where I have approached and dam safety committee has said it has no jurisdiction. Therefore, my lord, a similar order in the manner your lordship is passing.
No, no. That is
IA
not-
4 of 24.
That we know, sir.
IA 4 of 24, if your lordship. please.
So you approach the dam safety committee pursuant to which order?
Pursuant to 2424, my lord,
2494.
where the 3339 was disposed of. my lord.
Where is that order of the dam safety committee refusing to entertain?
Yes, my lord. That may be seen, my lord, in annexure B.
Annexure D.
Yes.
B.
That somehow doesn't refer to
IA 4 of 24.
that order at page D, annexure D doesn't. The order dated 2nd of
Final order.
Yes, final order.
April
Exactly.
24. That is the difficulty. It on the contrary refers to 8/1/24.
8124 was the interim order, my lord.
Yes.
The final order was on 2424.
All that will pass the order and.
Your lordships kindly, that order was passed.
And
in the
about what about you?
In the main writ petition, that order was passed, your lordships. Taking into consideration in their writ petition, the writ petition is disposed of in similar terms. My writ petition was considered as suo motu PI.
We know everything. It is already argued. You just only answer what we ask.
Yes, your lordship.
Otherwise, again, you will be confusing. So your matter will also go on the same order.
Yes, I'm seeking modification of the order, seeking that for crushing only.
So your case is also that you are not engaged in the blasting activity.
I'm only asking for crushing, no quarry, your lordships. I'm only conducting crushing activities.
Not mining.
not mining. There's no quarrying operation at all, only crushing.
So no, there is no question of blasting at all.
There's no question of blasting at all. Yes, sir. And the other three matters, your lordships, are directed to be listed today, your lordships. They are not listed, your lordships. The connected matter 4010 was directed to be listed today.
So-
It is not being listed, your lordships. 4010.
So tomorrow, the petitioner of 19835, then petitioner of 29420, and petitioner and applicant of IF4 of 24. Three parties shall appear before the competent then committee, correct, tomorrow?
Please,
Tomorrow,
madam.
that we are passing
Please.
the order.
Grateful.
We will dispose of by the end of the
Yes.
30.
My lord had said on the 21st, they would appear on the 21st.
Not tomorrow.
No, my lord had said on Friday, 21st, and then we
21st.
were supposed to pass the order within 30th.
So we'll get the order. It is already ready, but we'll
Obliged, madam.
superfine it. And
Obliged.
we'll pass
Grateful,
on
ma'am.
to Head General and Mr. Sondi, so that any factual corrections.
Yes, my lord, may be passed out.
That's
There's a connected matter, your lordships.
pardon.
In that, there's a connected matter, your lordships.
Which one?
WP number 3358 of 2024. There's another writ petition, your lord.
Where is that?
It's listed today, your lordships.
My
Listed
lord,
to-
12.2. My lord, there the assistant executive engineer SESCOM, my lord, his service is awaited. That 12.2.
ये इसमें रखा है. We keep here on.
My lord,
Lordships,
his notice is awaited. My lord had observed that one of them had been unrepresented, and that is, my lord, Chamundeshwari.
Lordships, the order at Annexure A, page number 27 may be kindly looked into. Annexure A, translated is at page 29, your lordships. The reason given is the order dated 8/1/2024 passed in the said writ petition, your lordship. The electricity connection is stalled because of the order being passed. At page 31, last para, your lordships. Therefore, hereby informed you are temporarily suspended all crushing activities in your Patta land so and so. Pandavapura immediate effect with further orders. Fill which
You're appearing.
I am appearing. The
Here also only crushing is involved.
only crushing involved, your lordships.
My lords, I beg to appear on behalf of the amicus.
It is.
He's on his legs before the Supreme Court. His presence may kindly be excused, my lords.
Welcome. So this will also go along with the common order.
May I make only one more submission? The
So
connected
this-
matter.
This will be finally disposed of,
Yes, your lordships, finally.
except first petition, where the order will
19835.
be treated as interim order.
Yes, your lordship.
All other writ petitions are disposed of with these directions.
Yeah.
Correct?
Yeah.
Please,
The other matter which was supposed to be listed today, it is not listed. Writ petition 4010 of 2024.
No, my lord, that is different, my lord. That is
Tomorrow,
Same
tomorrow,
very well.
tomorrow, day
Yes.
after.
Yes.
It will follow, if it is same, it will follow this order.
Yes.
The reason is there I am seeking only deemed extension. It is not been considered in view of the order passed, interim order passed 8/1/2020.
Anyway, when it is not listed, we will not,
Tomorrow that may be listed. I'm only.
My lord, day after, my
day
lord.
after, day after,
Day after.
day after.
Item 13 also, my lord, will follow the same order, my lord.
Yes.
Yes, Mr. Brahman.
Item 13 also same order, 29420.
Done it, Advocate General stamp.
So this will dispose of all petitions. As far as the main 13985 is concerned, it will be interim order.
Please.
That petition will survive. We discreet as a PIL.
Please, my lord, first matter PIL, my lord,
Rest of the petitions and IL will be dissolved.
disposed of. My lord. Please, my lord, insofar,
Your I is dismissed.
doesn't matter.
No, no, I leave it to madam. My lord, we were not informed about the previous order. I apologize.
All IAs are disposed of in the terms of the order as well.
Obliged, obliged.
In fact, my only other thing, my lords, can I make, to comply with the your lordship's earlier order, we mean, insofar as the blasting is concerned, my lords, we have appointed a committee, my lords, we may require some time to comply with your lordships.
Which one?
That is 1st January 2024.
Which
8th
8 January 20.
8th January 2024, my lords. To comply, another 12 months will require, my lords.
Yeah, what?
To, with regard to blasting, whether mining activity can be permitted or not.
That is not subject matter.
8th January, 6th January, show me the order, please.
8 January, it is there, your lordships. Page number 10 order, your lordships, in 8 January.
Very paragraph.
First page, my lords. Your lordship,
3.2, your lordships. 3.2, page 2 of the order. In para 8 of the order dated 5/3/2024, passed in the present proceedings, it was observed by the court that the granting of time was necessary for the committee to enable the committee to comply the proceedings. It was directed the entire works to be completed within 10 weeks, and the report shall be submitted by the court. The report of the committee is awaited. This was modified on 31/7 again, your lordships, because they told they can't do trial blast. So arithmetical calculations, and that's the reason it was posted on 14/10, your lordships. Again, after that, now again they are seeking time, your lordships.
so therefore, trial blasting.
Where is it? Page?
Your lordships, 3.2, your lordships. Para 3.2, page 2 of the
Necessary production. Paragraph?
3.2, your lordships.
Order dated?
Order dated 8/1/20, sorry, order dated 31st of July 2024.
Then it is all right, 31/7.
Because trial blast, they told they cannot do, so the order was modified on 31/7/2024, 3.2, your lordships.
What is the present method they want to do?
About the blasting units.
What they have said is with blasting, Manoj, we don't want to do it with blasting because again, it will affect the dam, Manoj. So now we are given the Indian Institute of Science, Manoj, to do it. So at least it's.
That will extend.
Please, that's the only thing we request, Manoj. And if possible, we'll do it the earliest because they wanted the time to
So
give.
in the interim order in this 18395, I will add the last sentence of it.
Please, Manoj, grateful to.
Mr. Advocate General, the rough copy of the order will be available to you in the afternoon.
Please,
You and Mr. Sondi,
Yes,
in
sir.
capacity of Advocate General, not representing state. Just
Please.
go into it and
Please, I understand.
textual thing is said, just suggest it.
I'll come in the afternoon, look at it. Any suggestions?
Get from anybody of my own.
Please,
Else is forward.
please.
How much extension you need?
12 months, Manoj, 1 year.
Another 12 months.
Because actually there are only 8 licenses as I pointed out, Manoj, because ultimately we were not giving any future license at all till the report is done. We were doing,
And 6 months for the
Will-
time being.
if required, we'll come back, Manoj. Well, 6 months,
That will keep it up.
please. We'll try and do at the earliest.
Other matters, day after tomorrow.
Which other matter?
4010, your lordships, very
That-
nice, sir.
yeah.
That other matter.
Yeah.
Day after tomorrow. Much.
Or it is given tomorrow, then tomorrow, whenever it is.
Tomorrow.
Number 14.
12 is disposed, of. All 12 are disposed. Except this 198. Not for it. Thirteen also. Only this will remain pending, 198. Go council. Including. It is also disposed in the efforts.
This. Number 14.
My lords, I'm just submitting the written submissions, since my lords on the lake matter.
The lake.
Lake matter.
The written submissions along with judgments, since my lords, in fact, some Supreme Court decisions are also, it looks bulky because the judgments are there. The submissions are not bulky.
You're
I've
welcome to submit.
I'll submit my written submission by 2:30, man.
Yes, if I can just, I've served the government and the BBMP, served copies.
Please.
We've also produced a few recent decisions of the Honorable Supreme Court on the point, so that it may assist my lords.
Just
In fact, we told you that it's bound to be bulky.
Yes.
Respondent number 14, we have also submitted our written arguments. Very brief note. Mr. C.K. Nandakumar, Senior Counsel, appeared on the other day. We have already submitted.
Malad, one aspect is very clear, Malad. Ownership of these lakes are always with the state. Custody is with the BBMP, Malad. There's no. Now the question is, Malad, all the judgments having gone through, they say public private participation has to be there. Now the only question is of implementation, Malad. What we are doing is implementation, Malad. The case of the petitioner is implementation should be done by the BBMP by taking an agency. That's the narrow scope of dispute, Malad. BBMP should take the money from the third party or the corporate entity or XYZ, and the BBMP should take the money and give it to a third party. Our whole contention is, Malad, whoever is coming, one pursuant to a transparent method, Malad, through paper publication, which we are detailed in our affidavit, Malad, anybody and everybody can take the best suitable entity, either NGO or individual or corporate, no distinction will be made. The best person to suit will be given. They'll call for notification and they will execute the work. Period, maybe maximum period is 2 years, Malad, ranging from 3 to 2 years, 3 months to 2 years, depending upon the nature of work. After that, it will come back to, not come back, it is always with us. They will have no right. So therefore, Manoj, the apprehension that ownership will go, custody will go, commercial activity will go, even though as of now, as per the various judgment, commercial activity is permitted, we have not envisaged as on this day. The MOU strictly prohibits any commercial activity, Manoj.
In fact,
And this is just 2 minutes, I'll just complete. The only purpose is, Manoj, lack of funds. If public funds comes through, Manoj, where they can get income tax benefit, Manoj, it will help the state also. That is all, Manoj.
So you don't have the funds.
Manoj, any funds from for anywhere is always welcome because we can use the state fund for better use, Manoj.
in fact, this matter, my lords have been extremely patient and heard us. Now the time limit is now coming up to 2 years. Nowhere in the policy or the
Well,
draft,
written, my
even
lord.
this 2 years has been stated. And in fact, we are relying on some decisions of the Honorable Supreme
Manoj,
Court
your
on
lordship will write it in the
on
judgment,
the
Manoj.
public trust doctrine. No, 2 years.
Your lordship will write it.
No,
Manoj.
Doctrine of public trust.
Yes.
That's the.
Under the public
Manoj,
trust doctrine, any commercialization, they may say it is not for commercialization, it is for rejuvenation of the lake. But if a corporate entity has.
Page 21, I've stated. My learned friend said it's not been stated. MOU shall have in a lock-in period of date of 2 years for the signing of MOU. Well, ultimately, for example, a lake may require 3 months work. It may require 1 month. When we're giving out tenders, it says maximum you complete it within 2 years.
Ultimately, for 2 years or how many ever years, the lake, if it is in the custody of a corporate entity, My lords, the public's use is restricted. The corporate entity is going to utilize it for commercial interests, which it will have in mind. And in fact, in a number of decisions, the Honorable Supreme Court has said that this cannot be done. Ultimately, it is a public trust doctrine. My lord have in fact heard us. And we are very satisfied that my lords have in fact understood all the issues from the different sides.
We'll
And-
try to become as exhaustive as possible.
Yes.
Just one submission in reply. In fact, we have written, there's a website also, my lords, and a toll-free number also which we are given. If any commercial activity is going or any violation of the undertaking given to your lordship or the MOU, they can call and complain, my lords. In 1533 is a toll-free number for which any violation is there. They can immediately call and point out. And there's under the act, there's a committee also, my lords. The Sahaya app is also there. They can call, my lords, whatever I have stated, we will amount to contempt, my lord. We have filed it, sworn affidavit before your lordship. There's the act rules and.
This MOU is only a suggestive draft.
My lords,
And
any.
it will vary as per the case to case.
And one more thing, my lords, your lordships have given opportunity to my learned friend more than 5-6 times to correct this draft, add or delete. That has not come forward, my lords, till now. I'm with great respect, I'm saying, my lord, that has not come forward. And I'm even now, if my learned friend wants to any correct, add, we are open to it. Nobody is arguing against public trust doctrine. Nobody is saying that we'll hand it over. You know, only question is, my lord, lakes needs to be maintained. We need funds. So the, my lord, ultimately, my lords, what they're saying is, let the funds come to me and I will do it. I said, let it not come to me, let them do it. Anybody will accept my learned friend's offer saying that let the money come to me, my lord. I mean, I can't say anything more, my lord.
Lordship in 14.4.
I rest my argument. Sorry, I'm not.
Yeah, affidavit.
1 minute, sir. I'm not again going to reopen the arguments. Our submission on it was that the MOU you can have with a registered society, residents association or an NGO. You cannot have it with a commercial entity. The commercial entity can only give you funds. If their issue is that we don't have funds, you can certainly take funds. But as per the previous orders of this Honorable Court dated 4th March and as per the advisory of the central government, the funds can be received. But the entity doing the work either has to be BBMP itself or some entity which has technical expertise and is a registered trust and has conservation experience. It cannot be some real estate developer who will just come in for money. You take the money. If they don't have funds, you take the funds. But then what is the role of the BBMP? That is our submission. And the reason where these kind of commercialization under the garb of taking funds, commercialization has been banned is because natural resources have to be secured as under the public trust doctrine is our submission.
Lordship in 14.4. Filed my detailed response to the affidavit filed by the PPMC. In that, very clear, 4th March 2020, the Sama Court has clearly passed an order. You can't hand over anything to the corporate entity. You can receive the funds. They have not made any effort to file an application or modification of the order. Simply they come up with a memo and I think they want to bring a policy. This policy, it can be as Learned Senior Counsel submitted in the other matter. It can be only by any NGO or a society. But it cannot be because corporate means it goes to a private entity. It cannot be permitted at all because who will going to monitor? Because there is so many things. Now your Lordship kindly says several orders have been passed by the Sala Court. I also referred to various orders and directed in my response. Till date, no, and today it has come up in Vijay Karnataka paper. Now regarding buffer zone, they want to form roads, your Lordship, and also lakes and other things. Okay. Include various orders passed this Honorable Court. First, let them say what they are going to do with the earlier orders. Because of the encroachment other thing, now they have come up with this policy. What they are doing all along from 2014 onwards. Neary report has given. They identified the places where all the encroachment. They are not touched at all. Now they want to have a buffer zone.
We have heard.
On roads they have to form.
Enough heard. Now,
section 12 of the.
at the conclusion of the last hearing, what we discussed amongst us is this. How many lakes are there in Bengaluru?
185, no? 183. under the custody of BBMP, my lords.
So we are concerned with.
Only with the 183 lakes, my lords.
183 lakes.
Please, my lord. The nature of work to be done in the 183 may differ from each one of them, my lord, and the time period to complete the development or restoration or maintaining may differ from period
That is
to
correct.
period. And the
Now-
funds required also may differ, my lord.
Now, there must be an official revenue record
Yes, my lord.
indicating the area of each lake.
Yes, absolutely, my lord. The extent of lake boundaries.
In some lakes, there might be encroachment.
There are
Yes.
encroachments in many lakes.
Any lake.
In fact, in some areas, this
Well,
court
that
has
is-
noted
that has nothing-
encroachment is by government itself.
No.
There is
Don't make a,
encroachment.
that's all the problem. We are not. Why
That
are
is
you?
the problem. Ultimately,
Well,
there
So
is.
that's what that is
Let's
what we are
discuss
addressing.
something. Why are you getting offensive about it? There is
Not-
encroachment.
Just giving the
Well,
facts.
Your Worship, we'll remove the
So-
encroachment wherever the encroachment is.
So you give the area
Please.
from your official record
Yes.
along with the list of the lake and the area of lake as recorded in the official record, revenue record.
Please, my lords.
And the, while executing MOU, same area shall be handed over.
Please, my lord.
And they will have to work in the same area.
Please, my lord.
They will earmark the boundary.
Yes, my lord.
And if there is an encroachment, before handing over under the MOU, we have to remove it.
My lord, can we do one thing, my lords?
My lords,
Uh,
on
But
the,
there are-
with great
there are
respect, on the issue
two
of
possibilities.
MOU itself, we
kindly,
are
I have the
opposing.
court, no,
Two
let's-
possibilities. Area of lake which is encroached, then it will remain encroached unless you take steps.
No, that's
And it
true.
might happen that the agency which is coming to work to develop the lake may also encroach the
No, my
lake.
lord, that question may not, I mean, my lord, this is all created my lord, confusion. Let's make it, my lord. If you remove, wait for the encroachment to be removed, my lord. So your lordship may monitor, we'll tell you which are the encroachment, my lord. Your lordship may deal with the encroachment separately, my lord.
No,
No.
precise exact area you have to hand over.
No, we'll give the exact area, my lord.
Otherwise, the
No, that
MOU
is
will
not a problem.
work.
That should not be a problem, my lord, because for example,
Will not work unless the area is specified.
no, that area will be specified, schedule will be specified, we'll put a sketch also along with the MOU. There's no difficulty along with identification area which has been, for example, there are certain lakes, my lord, which may be 100 acres, out of which 1 or 2 acres, because of legacy issues, my lord, may be encroached. So when we are giving to them, my lords, out of assuming it's 100 acres, we'll not, which encroach area may not be in a position to give it to them. We'll give only 98 acres. We'll remove the encroachment. It's our duty to remove the encroachment. Your lordship may monitor the encroachment separately. Because if you give it to a private party to remove encroachment, my lords, then it will become difficult.
No, you remove then execute.
Then
the-
till then, my lords, assuming for till then, it may take 6 months, 1 year. Maintenance of the lake will get affected, my lords.
No, part of the
But
removal
how can you-
encroachment is also
Well-
maintaining the lake.
Well,
Removal of encroachment is also maintaining. In
Well,
fact, that is the
In
part of the work. They can't
Encroach-
say, let
my
the
lords,
encroachment
the-
hang.
My lords,
They don't want to remove.
my lords, remove, immediately we try to encroach, there will be a writ petition filed, stay will be
Of
granted, my
course,
lord.
then you have to-
Your lordship, I'm telling my difficulty, my lords. They are not, I mean, this argument is contrary to the interest of the lake, my lord. The reason is this. What is your lords, what the argument is, just because there are 2 acres of encroachment, don't develop 98 acres till the 2 acres is developed. My lord, there are 2 different issues. Maintenance of lake, development of lake is one. What I'll do is, my lord, each area, each lake specific what it is and what is the encroachment area, we'll put it in a sketch.
Okay, what is the nature of encroachment? Construction of.
Construction would have been
I'll
put up,
just
buildings would have come up, my
In
lord.
fact, I'll point out one
No, it's not, these are not,
example.
these are not
One minute,
encroachment.
sir. On 20th October 22,
Hello?
just one example, Subramanyapura Lake. 20th August 22, there's an order of this
My
honorable
lord,
court.
let them give one
1 minute,
solution,
sir.
my
No,
lord.
no.
They've been arguing so many days. Let them
says-
give one solution, I'll sit
It-
down, my lord.
No, in fact, it says that in that lake, Subramanyapura Lake, there is an encroachment. And here it says that in view of the stand taken by the state government, we deem it appropriate to direct the learned additional government advocate to produce the original records for the court in respect of Puttanahalli, Shri so-and-so council for BBMP shall apprise the court with regard to steps taken for removal of encroachments. In fact, this
What you're
honorable
reading,
court.
some order you're reading.
Yes, in fact, 20th October 22, my lords, we have been handling this matter for the last 10 years. Neary report was done. Every lake, what is the encroachment? They looked at it. Every single lake, one by one, my lords were looking at it. And what my lords are saying is absolutely right. Each lake, there is some encroachment. Then that encroachment, what is the nature of that encroachment? Whether it is private or government, what has to be done? It can't just be handed over, my lords.
My one submission.
In fact, even the records of each lake, my lords had in fact asked. Ah, could I just
Your
make
lordship,
one
my
submission?
lord,
How many petitions are there?
how many?
Like, my lords, ours is the lead petition 38.
My lord, great, these are.
401. My lords, may I just make one submission? Each lake has a different issue, different problem, and there cannot be a one solution for all the lakes. So my submission, my lords, every single lake, what is the level of encroachment, what is the maintenance done, they have to, BBMP has to give a record. What is required to be done? And for that particular lake, a tailor-made solution has to be crafted. To open up all the lakes for private MOUs, my lords, it will be a disaster. My lords raised the question. Supposing 2-3 acres are encroached, some private agency will come. In that encroachment, 3-4 acres more will be encroached. Who is going to keep a watch? My lords, these encroachments.
My lord, let them give one positive solution. Let them.
It's not about.
I will give to my learned friend all 185 letter
Not
maintain it.
seeking
What kind of
any,
arguments are being made?
No, this
a-
is my lords raise the risk. My lords, ultimately, this is nobody's private interest. My lords raised a very valid risk. Supposing 2-3 acres, there is already encroachment. Some other agency will come and
Even the developing agency may encroach.
yes, that is the risk. So before even maintaining the lake, part of the maintenance is removal of encroachment. You remove it, BBMP should make a fence, and then the lake, whatever is the maintenance can be
Policy
done.
will not give it to my learned friend's clients. That is decided, my
No,
lord.
we don't want
My learned friend's clients has got vested interest, my lord.
no interest, and we are not.
Personal
seeking
interest and
anything.
vested interest, my lord. We don't want to give to them.
We don't want also. No one is applying also for it. Where is the question of us taking anything?
Your lordship may make one submission regarding encroachment. There is an order passed by.
My lord, my respect for.
2023 on IA 1 of 23, wherein the lake, Malatali Lake was 72 acres was there. Your lordship. Now it has been reduced to 40 acres. 40 acres. And contempt is pending.
Before we,
The road, 80 feet road they formed. Who will be protect? Contempt matter is pending because of that.
before we reserve,
Connected matter.
keep the judgment reserved.
Unless all these issues settled, they can't finalize this MOU. That's my submission. Let them first come out with clear how they are going to remove all the encroachment. Because the private entities cannot remove the encroachment. It is only the Lake Development Authority or the authorized officer under the contact authority only can do it.
That is all.
That is only,
That
that's
is
what the
all.
detailed order passed by the Assembly.
That is all. So when you are going to give the list of the lakes with area
With
as
the
recorded,
encroachment and the area and how much of it is.
so before we,
More I'll give it, my lord. We have
before
the
we,
data with us, my lord.
because that's the material information
My
you
lord,
will be
your lordship may
supplying.
kindly see, my lord, the
Any
bank-
error will cost you. And error in discrepancy in that will also render the judgment.
And how much is the
My lord-
encroachment for each lake?
My lord,
The area and. how
Area
much
and
is
the
it?
encroachment.
Yes. What is the actual revenue area?
I don't understand, my lord.
Because we are regaining the lake itself. So
Yes.
area and the encroachment is very important.
Yes, and we have to revive. We can't let that
Revival of
go
the.
away. 4 acres are encroached. We can't let it go away.
So my learned friend's argument, let 4 acres, 96 out of 100 acres, 96
There is a
acres.
lake of 4 acres and only 2 acres is open. Rest is enclosed. Then you will and develop only 2 acres.
Exactly.
30 acres have been enclosed in that.
So
lake.
without my answer, my lord, if my learned friend keeps saying exactly, I can't be able to reply
I'm
to her.
confirming with the honorable
Even
court.
he is aware of.
So you first find out,
Commissioner.
My lord,
First
I'm
find-
trying to find a solution to.
debating today, first find out the list and also find out the number of lakes where there is no practically no encroachment.
Then I think all 183, there will be something or the other, my lords.
To the extent of.
Let's be, on facts have to be very clear to your lordships, my lords. So the idea is two things, my lords. Encroachment is the responsibility of the BBMP to see that, my lords, not only government, private government also has encroached on certain things. We have to take those stock also, my lords. That is why we have gone deep into it, removing all encroachments, my lords, insofar as these lakes are concerned. So therefore, my lords,
We'll remove the,
please, my lords.
we will remove the encroachment.
We will remove, my lord, therefore, my lords,
Yes, then they remove it, let them
my lord,
remove it.
that's why I am trying to point this out regarding from past 5-10 minutes. Encroachment is our responsibility, my
Our
lord.
order should not be unworkable, nor it should be misdirected in the sense that we
But-
permit develop the lake with encroachment.
Yes, that cannot be. First, let them give a data of all the lakes, the total revenue extent and how much is encroached. And then by when they will remove the encroachment, some timeline.
Yes.
By when
Look
they
like-
will remove the encroachment.
Look like, my lord, my learned friend has conducted this case for 10 years. Another 10 years is the,
We want the
another 10
lake
years
to
is the
be
agenda.
encroachment.
My lords,
It may take.
my
half
learned
of a
friend
year.
has conducted this case from 2014 to 2024.
They have abdicated.
has pointed out what are the encroachment.
Get the detail. First we get the details, then
My
we.
lords,
Yes.
kindly see, my lord, this petition has gone on from 2014 to 2024. And till day, my lord, they have not been able to remove what my learned friends are arguing, achieve anything, my lord. Now,
they
what we
have,
are not,
with the
what
court
we are
orders, it
trying,
has been
now
removed.
what we are trying to do is give a closure to it at your lordships.
We are
which-
doing, we will be closing them.
Therefore, my lords,
We
your
need
lordship,
the data. We need the data, my lords. My lords asked.
within one,
My
my
lord.
lords, I said I'll take 24 hours to give the data. In 14 years, she has not done that.
I
Let her
should
not.
have the data. It is the
Thank you.
government land.
My lords, it should have been done earlier. My lords, when we have come forward,
Hours or 24 days even.
Yes,
Not
yes,
difficult.
let them give.
my lord, the question is this, my lord, the question of encroachment should not be mixed up with the point.
No, we are mixing it up
Yes.
deliberately.
To be linked.
Because the policy to regain or redevelop the lake should not be a tacit
Yes.
permission to encroach.
Just let go of
Then
the
I'll
lake.
leave it at
Yes.
that, my lord.
Yes.
Even I'll leave it
Yes.
at that, my lord. We'll give the data, then we'll probably.
We are not,
Because, my lord, my honest opinion,
we
my
are
lord,
not doubting your bona fide.
my lord, my
We
honest,
want our judgment to be clear cut,
my honest,
effective, workable
Yes.
and honest.
my honest opinion is this, my lords. The moment your lordship say that encroachment, only after encroachment, honestly, the encroachment to be removed in each one of the lake will take several years, my lord.
First you gather the details, Mr. Raghuvan. Then
I'll
we'll
give it
say
by
what-
tomorrow morning, my lord. Tomorrow by 10:30.
Once you get the details, we'll able to find out some way.
No, my lord, by 10:30 tomorrow morning, the information
Then-
will be available with each exact with documents, which all thing, my lord, and that will not change forever, my lord. It is gone by what it is, and it
Be
will,
on the revenue.
and we'll file it with an affidavit also, my lord. There's no problem. Then the next question would be, my lords, it's not that it is vacant, there are plan sanction taken buildings. Once we start doing it, my lords, it will definitely take time, which is not done all this time. In fact, my lords, if your lordships monitor each one of them, like make them party and demolish it and get it back, I'll be happy, my lords. To get back this,
We'll think over.
Yes, let them give the data. Let them give the
Don't-
information.
Don't jump to 24 hours. You
Yes.
find
it's
the
ready, my
details.
lords. In
No, no,
fact, I think
no.
my learned friend says,
No, gather the details of the area, lake, area,
And encroachment.
encroachment and nature of encroachment.
Yes. My lords
nature
are
of
grateful.
encroachment also.
Because we know.
Nature of
whether what-
encroachment will take some time, my lord.
Yes.
We know the,
No hurry.
Yeah.
We are not in hurry.
Because the nature of
My lords,
encroachment is
don't
very
we
important,
want-
whether it's
We don't
government,
want to
private,
rush up,
what is
don't
the.
want to rush up the.
Yes.
my lord, the reason is this, my lord. What has happened, again, the lake developed.
Encroachment is less or removable. We can immediately switch over to development of those lakes. Encroachment is cumbersome, difficult to remove. There are a lot of practical difficulties. Then it can be postponed to a future date.
So nature of.
Well,
encroachment is very important, my
Just,
lord.
my lord, there are last extent of encroachment, my lord. So now assuming, my lord, there are water body which requires to be maintained. It's not the land which you're maintaining, my lord. Lake is the water body which requires to be.
Anyway, once you get the details, then we'll discuss the means and how to come out of that.
Only thing is, the rest of the data will provide tomorrow.
The humble
Encroachment, each
suggestion.
will visit each lake all.
Let them give it
Each lake,
together.
my
Let
lord.
them give it together.
Together.
Yes, let.
I'll give it together, that should.
First August 2023. There is an answer for our Mr. Leonard Aegis, first August, no, already filed it with page 4, you are. I filed it in the connected matter.
They must be having the data.
14. I'll give you a copy. My copy is. I'm giving my copy.
Which paragraph?
Giri report.
For first order, page number 4, you know. The detailed order. has been passed
But
by-
in fact,
followed
there's
by
a
September.
Neary report with regard to all 183 lakes with the encroachment. Will,
Aye.
yes,
Is there?
is there, we'll place it, that also. It's already before your lordships. We don't have a copy, it's already who has
Separately,
given it.
The Neary
Neary
report,
has
my lords,
directly
is
given-
extremely bulky.
separately place it.
It is,
You-
each lake is a big compilation because
Even
they
if
have.
it is
There
part
are
of,
14 volumes,
even if it's
Yes.
part of the record. 14 only.
14 volumes.
So that should be summarized. It cannot each lake
We'll
review
give
that
it, why is
Neary
my
gave.
learned friend, I mean.
No, but my lord, sir, the honorable court is asking.
We'll make out
for
of
it.
80, I didn't know, my learned should.
Don't want the entire report. We want name of the
Yes.
lake, area,
Extent of
area
encroachment.
where it is located, extent of the lake,
Please,
lake area,
An independent agency has done it.
went or not, and if it is.
Yes.
We'll do that.
Picture of encroachment, yes.
My lords, independent body has done it, which I just came to know, my lords, which is there. We'll go by that report, independent report itself.
It is for
So
you.
therefore, my lords,
Court, we are, in fact, this court, in fact, appointed
I'll go by
Neary,
that
they
report.
paid for it, and Neary did an extensive job. But each lake was like a bulky report because they did an extensive report. My lords may not be able, none of us will be able to see every.
I'll do it, my lords.
Let
Let me
them
learn,
summarize
I'll sit and do it.
With
my
the details my lords are asking, so my lords would be, it'd be easy for my lords to understand for each lake.
That is summarized in the first August 2023 order. First August and followed by 4th September. They filed
14
an
volumes.
up to the art pass.
Court officer, court
They filed
officer.
an affidavit
Court
that
officer.
has been passed
Volume
by
is the
5th
other.
September, page
Tell
number
his
7.
person.
It is not just we are coming here and
Pollution Control Board will not come in picture. Both of you are standing and smiling.
they are also party. It matters. We have made them also a party.
You are not in picture.
No.
They're watching the pollution happening.
And in fact, Neary gave the recommendation also for take what is the encroachment, what is the nature, what should be done. Even that,
Then we'll.
Well,
proceed.
can we
That-
borrow the, we don't have the copy.
Any-
but it's-
take
Can we
your-
borrow the copy from your lordship, which is 14 volumes, my lords? We'll make it one compilation, one index kind of a thing, and give it to your lordships, my lords. In fact, if that was, we'll place it, my lord. All these volumes are here, my lords. Of all
that in fact it's far more. Yeah. It's more than 15, 20 volumes. Far more.
Well, this is called Study of Lakes of Bangalore City, Protection, Restoration, Rejuvenation, as per the directive of this honorable court, my lords, 2020. So we'll go by this report, my lord, and then we'll act on it.
It's for you to vote detail to.
I'll,
Go by your detail. Subject to their vote says.
my lord, my angst. They're not given. That's not good.
Each lake has been identified and survey numbers are given. Where is the encroachment? Because the
This should have brought to the notice of the court first, my lord.
location is given.
We should have brought to your lordship notice. This is the
Oh,
first, this is the. I will study it, my lords. Can I,
There are 8 matters. 8 petitions.
eight, petitions, I'm not sure.
How many?
My lords, the lead petition
So
is
eight
asked.
petitions
lead
filed by-
petition number 1.
8 petition filed by a different advocate,
Yes,
different advocate. So each of the advocate is requested to give in a separate page only the prayers in each petition. By the time learned advocate general gives the details of the lakes, you will give the details of your prayers only prayers in each of the petition, right?
18 June 2019, the detailed order passed.
And one other thing, your lordship may monitor the removal of encroachment by the BBMP.
That
my lord.
will
You monitor that and will submit reports to that, my lord.
mechanism and modalities will think later
Yes.
once you give the detail.
Please.
Great. We'll do that.
Manoj, one other thing, we are not shirking our responsibility in so far.
Nobody says.
In a sense, my lord, so therefore, my lord, our intention is fully to see that encroachment is also removed. At the same time, my lord, it is not worsened.
The whole idea is that if the lakes are to develop, it should be fully
No,
developed.
no, it's not developed, my lord. Here,
All encroachments
Removed.
and the evils are
correct.
clear.
My lord, we are not looking at develop. We are, first of all, basic thing is to maintain it and restore it, my lord, because there are a lot there are a lot of sewage problem, lot of people for.
We will not permit the development of lake in guise of
There's no development.
guise of regularizing the.
My lord, there is no.
And
your
that
lordship may
encroachment will remain.
Ah,
It may remain. Then then we have to now file a new petition, my lords. In
My
fact,
lords,
many
there-
of the
whole purpose will be different.
purpose
My
of
lord,
such.
there is no development of the lake, my lord. There is only maintaining I hope they maintain the lake enough, my lord. Further development is not required at all. What they're doing is preventing the maintenance of the lake.
Whatever, but it should not be.
My lord, what they're saying is don't maintain this lake till the encroachment is removed.
In guise of that, we will not permit
It is
the
otherwise continue.
encroachment to subsist and
No, no.
regularize.
What my learned friend is saying, okay, don't maintain the lake till you remove the encroachment.
No.
Yeah,
That is
see,
what is coming up
that is
to.
that is not.
That is what is
that is
coming
not
up
a
to.
fair. That is not
That
a
is what is
fair.
I'm
statement.
only
That is not-
asking,
no one is saying
I'm
that.
only saying, permit us to get
That is
money
not
to
a
maintain the
fair,
lake. Get
permission.
All that they want encroachment to be removed. You want
But
the
the
lake to be,
maintenance-
lake to be
No,
maintained.
I want both.
Yeah.
I want both.
So want both.
Yes,
I want both, my lord. It's a
we all
misconception.
want it.
My learned friend is.
Both
arguing.
also wants both to.
I want both. And I'm requesting your lordship may monitor us on.
We'll monitor also.
Monitor also.
We'll monitor also.
We are saying our.
Let the details come. Let the details come.
Yes.
18th June 2019. 44 pages order have been passed in court.
We'll see.
Paragraph 33,
When you will give,
33 clause 1 speaks about the appointment of Miri.
we'll consider, we'll consider.
Based on that, they are given the report.
27th,
18th June 2019.
my lords, next week, my lords.
27.
Can I borrow, because the NERI has given the report, only one copy to your lordships, my lords. We don't have a copy. Can we borrow the copy and give it back by 27th, my lords?
Can it be
You can-
28?
28,
28, my lord, if it is.
28,
Any date.
then
28
Any
or
date coming to
29.
your lordship next week, my lords.
28th or 29th, in case my lords feel.
third,
Third, great.
third.
My lord, let the only maintenance and the removal of encroachment go hand in hand, my lord. That's all my request is, my lord. So let it go hand in hand. So therefore, my lord,
Yes, yes.
that's all my request is, my lord. Let it go hand in hand, my lord.
That is what.
Yes.
For that, we need details or.
No, please, my lord. That's all my request is. my lord.
I'm appearing in the first matter. Yeah.
I appear in 14.1.
So kindly give.
My one other
Prayers.
request.
My lords have asked
My
for the
one other
prayers. yes.
request to the petitioner is, my lord.
If possible, within 2 days.
From
You
2019.
will just type out and give.
Yes, yes, the prayers.
One other request to the petitioner, if they have any positive suggestion, let them give, we'll incorporate
Yes.
that, my lords, because till now I have not got,
Share
my-
that data. We
my
will
lords,
ultimately.
it will not take more than one page.
Therefore only we are not in hurry to close the.
Not adversarial.
So let them,
Years have passed, why should we hurry?
just, therefore, my lords, any positive suggestions, my lords, let it, place it before, we'll accept it, my lords. The only question is,
Advocate General was not there earlier.
2:30 every day, when the matter is to be taken up by the formal court earlier. Chief Commissioner was called, now earlier it's the Commissioner. And how they are going to remove all these enforcement? Detailed reports have been submitted.
We'll see,
So we
we'll
have to
go.
examine that and then come up with a, that's all, that then this problem, then maintenance will come afterwards. Once lake, we have to restore it first. Remove all of it. Once the lake area is restored, it can be definitely maintenance, we have no objection for maintenance of the lake. Because that is required afterwards. But first, removal of encroachment, they have to do it.
Very good.
Third, my lord.
And one other thing, my lord, I'll go for the steps and find out what are the steps taken to remove the encroachment also, I'll place it, my lord. Because instead of just going out and saying, let us examine what further also, what we have planned, what we have done till now, and how we need to proceed also, I'll point it out, my lord.
Don't throw the details one after the another.
No, my lord, one separately, my lord, then it can be, those can be monitored by your lordships independently, my lords. That may not be part of this independently.
The detailed order passed by Zonar Board on 4th September 2023. It's very clear order, how it should be maintained, lake and also the Solomon Drain. Affidavit has been filed by BD, both by the chief
We'll-
engineer of different.
We'll see that
so
order.
kindly go, your lordship, if the solution is given by this court.
Today night, we'll go to that, go through that order. 4th September.
My lords are given additional work. My lords are burdened with additional work. Grateful. Third.
Third.
So PL matters, number 15, Mr. J.R. Mohan.
Petitioner in this case. My lord, I have filed this writ petition for a direction to the respondents number 1 to 3 to investigate into the irregularities committed by the fourth respondent in utilizing the government funds.
Notice returnable on 12th December.
Number 16.
My lord, I have filed this writ petition
The
for a
similar
direction to
petition
the
was there earlier.
Presentations, my lord.
my lord.
Yeah, earlier similar prayer was
Yes,
made. in
yes.
one of-
Yeah,
Yes,
the
yes.
department is different, my lord. I had filed similar writ in.
To consider only representations.
No, earlier. This is the one. 15.
Only to consider representations, my lord, and my lord has passed orders in that, disposing of the writ petition, directing the concerned authorities to consider the representation.
To go
My
to
lord,
one.
I'll bring one, my lord. I'll give it to the court office.
Give disposed of in that line.
Much.
Disposed. What is your name?
J.R. Mohan.
You are J.R. Mohan.
Mhm.
Yes.
Double
So 16 disposed of. So within time bound to
My lord, 8 weeks, my lord.
expeditiously,
Well, no,
whatever
I'll leave it-
mentions, we'll mention that.
Very well.
Yes.
Serial number 16 is also the same.
No. 15 and 16 both?
Yes, my lord.
15
ma'am.
we received notice.
The 16 is pertaining to.
My lord, 15 is also to consider representation, my lord.
Earlier also similar petitions.
Yes, yes.
Yes, my lord, but the department was different in this case.
Here, madam, there is a.
Here,
some
the department
audit-
is.
Audit observer.
Then I'll leave it to my
That
lord.
is notice.
Obliged.
Much of it.
This is number 17.
May it please your lordship, I appear for the petitioners 1 and 2. This is a public interest litigation seeking to report number 2 to squad regarding chipping of
What is RPF means? Request for proposal.
Your Lordship,
Request for proposal.
Your Lordship, of the petitions, we are trying to seek a direction to the respondent number 2, BBMP, who are carrying out this activity of microchipping of dogs and implantation, which is illegal. There is no mandate which they have under the Act, and neither are they following the Animal Birth Control rules under the Prevention of Control of Cruel Animals Act 1960.
This RPF was in February. Now what is the?
In February, my lords.
So now it is a step. Yes.
My lords, that petition was dismissed for non-compliance of office objections.
Then how the prayer would survive in respect of RPF, which was 29 to 24.
The project is still being continued, my lords. There is no basis.
Opening of the RPF was 15/3/24.
No, it may have been then, my lords, but they have no legal basis to carry out this microchipping in the first instance. There is no BBMP not authorized under the rules. The Supreme Court orders are also very clear that you have to follow the Animal Birth Control rules for 2023. So BBMP has no legal mandate to issue a bid also. In fact, there is a letter where on page 1, where the Animal Welfare of India has clearly said that this microchipping is not an activity which the BBMP is authorized. We have written representation, page 171.
171.
Yes, my lord. A series of correspondence. In fact, the letter is from the Animal Welfare Board of India itself. Referring to my letter, I'll read out the letter. Sir, this has reference emails received from Ms. Jagdish and others. Sujay Jam, the petitioner number 1, where it is mentioned that BBMP has undertaken ABC program through NGO Asra, Sarvodaya and Care of Voiceless Animal Trust during ABC program without project recognition from the board, and there is lack of infrastructure. BBMP has included combined vaccination microchipping projects part of the recent ABC tender.
What is the tender for?
The tender is to procure microchips and implant it in the dogs. This is a methodology which is not permitted under the ABC rules. It is only for pet dogs under the 2017 rules. Nowhere does it permit under the ABC rules. So this whole mandate itself is illegal to have issued a bid in the first instance.
So what is the purpose of installing microchips on the dog?
Purpose for microchip is to...
Your voice, Mr. Counsel, is not reaching us.
1 minute.
You are from Bangalore or from outside of Bangalore?
I'm from outside, my lords. Is it better now, my lords?
From outside. Yes.
The microchips are implanted in the dogs. The purpose is to control the stray dogs in the city of Bangalore. They have carried out a pilot project in one of the zones, RR zone.
In controlling stray dog, there should not be any
No. It's not about controlling the stray. This whole methodology of microchipping is illegal. They can't have issued a bid. This is not permitted by ABC rules 2023. This letter also is very clear, my lord, 171, and we have written representations over a period of time. This is itself illegal. The mandate itself is illegal. It's a question of they are not authorized to carry out microchipping.
Let us see where are the rules. Which are the rules?
Yes, my lord. The rules are on page 63. ABC rules 2023, page 63.
Page 63.
Yes.
Is the
rules which have been notified.
Yes.
10th March 2023. These rules may be called number 1, and these rules may be called Animal Birth Control Rules 2023. Now, if you turn to page 66, rule number 9.
Yes.
Rule number 9 talks of formation of monitoring committees and its functions. The monitoring committee shall be constituted for effective implementation of animal birth control programs in accordance with rules to control the population of street dogs, for eradication of rabies, and for reducing man-animal conflict. And monitoring committee shall be constituted as follows, namely a central animal birth control monitoring and coordination committee for dog population management and rabies eradication shall be constituted to ensure coordination between the different stakeholders in the central government, between the central government and the state governments.
So we are concerned with sub-rule 4, local.
Yes, my lord.
animal birth.
Yeah, but that has not been, in fact, on the very next page at 67, 10.3, the local animal birth control committee shall be constituted by the local authority, and it shall meet once every month to assess the, in fact, this also has not been done. They have no authority.
Yes.
They have no authority to constitute this committee. This is all monitored under the Central Legislation of Prevention of Cruelty Act. These rules come under the Central Act. In fact, BBMP is not authorized to issue this mandate. They have no permission from the Animal Welfare Board of India, which is the respond number 3 in the matter. Nor has it consulted the Central Animal Birth Control Monitoring Implementation Committee, which is on Schedule 9 and at page Schedule 2 at page 77. Page 77, functions of the Central Monitoring and Coordinating Committee. The Central Monitoring and Coordination Committee shall have the following functions: to monitor proper implementation of the animal birth control rules, to promote the animal birth control program and arrange budgetary provision for the birth control in the states. So the point is, my lord, that they have no authority to have issued the bids in the first place. There is no SOP. They are acting beyond the powers of the BBMP Act and the rule. So this entire process of issuing the bid itself is illegal. In fact, the entire they used to carry out vaccination earlier for anti-rabies.
This microchip installation is for the purpose of birth control.
No, it is not. It is for to manage the stray dogs and all to also. Earlier, what they used to do, they used to paint, and there was an app which is to monitor for anti-rabies. Earlier, there was a methodology which was introduced for, which was a success earlier for eradication of anti-rabies. This is an invasive procedure which is not permitted by the rules. This bid itself is illegal.
Mr. What is the objective of issuing such
My lords, I'm yet to file wakalat. If I'm permitted, I may be allowed to get instructions in this matter, my lords.
So you will issue notice then. You
Yes,
file your reply.
I
Third
appear for
learned
R2,
senior
my
advocate,
lords.
Mr. So-and-so, so-and-so.
I appear for R2.
To make submissions, as well as learned advocate, Mr. Learned Additional Solicitor General,
Shanti Bhushan.
Mr. Santi Bhushan for Union of India.
For the first test.
And learned advocate.
R2, my lords.
So-and-so for BBMP, who appeared upon service of copy of the petition in advance. Full stop. Notice returnable on.
My lord, I take notice for 428. So all the
Add-
parties are served.
Government. Notice written on 14th December.
Grateful, my lords.
Little longer.
Grateful.
16th December. Learned additional government advocate waives respective learned advocates accepts notice on behalf of their.
Please, yes, my lords. Grateful, my lords.
Obliged.
Yes. Reply shall be filed to the case put forward by.
This green bench matters, syllabus 18 to Bhargav N.
I appear for petitioner, my lords. This is the matter, my lords, where we have challenged the notice issued in respect to washing the sand with a machine, wherein the, my lords, the
My
permission
lord, this will
accorded
not
for-
survive for consideration. My lord, for the reason that, my lord,
Well-
the petitioner had informed
Is
the
that notice?
My lords, in this matter, it becomes infructuous, my lord.
Very, this has been infructuous.
Yes.
Yes.
Learned advocates,
That's what I was.
So and so said that the petition has become infructuous.
Because land permission, my lords,
Closed up as infructuous without going into the merits.
may I file memo, my lords, with respect.
Like.
But
No,
this-
no,
yeah, it is up.
Files memo. So and so and so. Is
There
taken
is
on
some
record.
typographical error, so I written with hand marks.
It is stated in the memo that the petition has become infectious. Therefore, permission may be granted to withdraw the petition. In view of the memo, and as the become is stated to be infectious, dismissed as withdrawn without going into the merits of it.
Much of. Is still number 19 to Vinay Kumar.
Notice,
Council.
will issue notice.
Lord, it is only for consideration of representation, Lord. We are seeking direction against the forest officials.
You want some,
Consider-
forest lease to be executed.
No, forest lease was executed, Lord. MDPA was executed. 10 years back, stage 2 approval was granted. It is only for forest lease agreement, Lord. Subsequent to execution of mining lease.
So what was executed? Forest lease was executed.
Yes.
Now only agreement to be executed.
Agreement to be executed, my lord. They are sitting on the file for the past 8 months. Mining lease was executed, my lord, in the month of March.
Consider the representation annexure A. I'm not agreeable for the second portion of the prayer, my lord. That is to issue suitable directions to respondents 3 to 5 to execute the forest agreement. That I'm not agreeable. But if my lord were to say to consider.
But why are you not executing the agreement?
My lord, that I'll have to take instructions.
Notice.
Lord,
Since
let
they
them
want to
consider
consider only the
annexure B.
representation.
Notice written.
Lord, let them consider annexure B in a time-bound manner. I'll
Not
restrict
annexure B, my lord, annexure A we will consider.
Annexure B is what?
Annexure
That is
B
the
is the
issue.
representation.
A positive direction is sought at the hands of my lords.
My prayer is, your last may kindly see, my prayer is to consider annexure B, representation.
Or to consider
That may be
annexure A.
considered in a time-bound manner. A and B. A and B.
We'll issue notice in this matter.
A short date.
My lord, short dates, I'm being pressurized and then I'm attacked, my lord. I have to seek
No, my
instructions.
submission is, Lord,
No.
mining
your
lease was
submission-
executed in the month of March.
My lord, that's
They are
not
sitting
a long
over the
way
file
off. No, my
for the
lord,
past
that's
8
not a long
months.
way off. My lord has to give me at least 6 weeks time.
We understand.
Coming up.
Your vehemence and your vehemence, you understand because you are a colleague. Not too much. 17th December.
Oblige, my lord.
Wait.
Number 20. To Shivali.
This is the case where not pursuant to my application that annexure B, grant notification is issued at annexure G, page number 59. Despite issuance of this grant notification, they have not taken steps to issue the quarrying. Please.
What is this?
The petitioner has filed a AQL application in the year 2014 itself, pursuant to which they have issued all.
This is only for consideration of the application.
No, my lord, may see the second half. My lord, just 4 lines above. To consider the representation filed by the petitioner, my lord, over an area of 4 acres in government land in favor of the petitioner based on the notification in form GL dated so-and-so within the time limit as prescribed. Applications are dated 2014, my lord.
Application, it is true that it was.
No, I'll seek instructions,
Now
my lord.
law has been brought in according to rule 8B1.
Say that if this notification is applicable, you consider independent.
My lord, I'll just seek instructions, my lord, and
Take
then.
instruction. We are not issuing notice. When you will take?
My lord, sometime.
Third?
Third, my lord.
Third?
Yes, yes.
Third at 2:30. In order to send over to 3rd December to be posted at 2:30 in order to enable learned additional government advocate Srimati Nilo Parakar to take instructions with regard to the prayer made in the petition.
Number 21.
This is a matter where, my lords, state through City Municipal Corporation.
Argued, no?
Yes.
Learned advocate, who appeared, Ravi Kumar.
Ravi Shankar.
Learned
Right.
senior advocate Ravi Shankar, assisted by learned advocate Mr. So and so for the appellant. And learned advocate Mr.
Bhanu Prakash, minutes.
Bhanu Prakash.
Please, minutes.
Gangadhar for corporation.
Your advocate general.
Please, yes, my lords.
Learned additional advocate Mr. Bhanu Prasad for respond number 1 and
Please, minutes. Respondents number
so and so and learned advocate.
1 and 2.
Your
I'm for respond number 4, my lords, for the institute, my lords.
at length, the parties, learned party stated that they argued the appeal finally. They further stated the pleadings are complete and no further are required to be added or supplemented. Reserved for judgment.
My lords,
My lord, I have
state has not replied, my lord.
filed the impleading application. I will be permitted to come and record, my lord.
So for impleading this.
Yes, sir.
Impeding state contractor. my lord.
Appeal, how can you implement? Yes, next.
State has not.
First, it's before.
Not so.
I argued, my lords, but then since
Since we are the appellant, we started, state has to argue.
friend wanted to counter
One
only
second.
3 points, my lords.
Who are 7 and 8?
Seven at a private parties, my lords.
They are served or not served?
Not, notice is not issued in this case, my lords.
So deleting them.
They have nothing to
I'll
do with
file
this
a
case.
memo, I'll file a memo for seeking
This
dispensation.
case.
I'll file a memo seeking dispensation of notice against them, my lords. 8 and 9.
File memo.
I'll file.
Tomorrow then we will resolve. After you file memo.
Please, my lords.
Or we can
Tomorrow, my lords.
My lord.
tomorrow.
Please, oblige.
So this between the appellant and respondent 7 and 8. It is the dispute between the
That's right.
corporation on one hand and the appellants on the other.
Only thing that since we are reserving, everybody should be served. That's the idea.
Please, my lords.
If we are,
Oblige.
we never knew that somebody is not served. Otherwise, we would have dictated in the open for all.
Please. Grateful.
Now, since you said that we are reserving, then let the formalities be over of deletion.
Yes.
Yes.
So number 22 urgent, so number 23, the state appeal.
23, state appeal, my lord, there is a delay of 500 days.
Delay notice returnable on,
Please, my lord.
say, January 20th.
So number 24, Mr. Chandrasekhar L.
State has to serve copies on me, my lords. Copies will have to be served on me, my lords. That's this office objection also.
Pardon?
There's a report which has been filed.
Oh. So
To
it is no
receive the-
notice is issued so far. Fresh matter.
Notifications are-
Fresh matter, my
Let
lords.
us see what is it about.
Copy, yeah. It'd be taken up next week, my lords. I'm a little short of preparation, my lords, because it was posted for meeting with the office objections.
Anyway, this is not posted for office of, we can grant time, no difficult. What is that circular? You're not ready today.
I'm not ready, my lords.
4th of December.
Obliged.
Number 25,
Date.
Abhishek K.
There is a delay of 51 days, my lords. Challenge,
Notice written over 20th January.
much obliged, my lords.
Twenty-six urgent, seal number 27, to P. Karumbaya.
21st January, no, 26th, 7th. 27th.
Notice. Seal number 28, Mr. Abhinav Ramanan.
27th, no, counseling.
But 28, Abhinav Ramanan.
Matter pertains to, my lord, Hindu Religious and Charitable Endowments Act. Lord, that act has been struck down by this honorable court. My lord, the judgment has been stayed by the Supreme Court. So, my lord, what the learned single judge does, my lord, is he upholds the order passed by the Special Deputy Commissioner, invoking the provisions of an act that has been struck down by this court. My lord, now if there is a dispute under the act, whether a post is hereditary or not, my lord, the Deputy Commissioner can conduct an inquiry, my lord, and decide. That is under the act, my lord. That act has been struck down, my lord, by this honorable court. And there's a stay, my lord, in the Supreme Court. So whether, my lord, the Deputy Commissioner powers under a provision which is struck down as unconstitutional by this honorable court, my lord, would be the question.
Notice.
Lord, now there is a, my lord, I request for an interim order for this reason. The petitioner, my lord, is working as an archjudge. Now, my lord, the learned single judge, my lord, has directed, my lord, the Special Deputy Commissioner himself to, my lord, conduct an inquiry.
You find out what is the stage of process.
Very well.
It is there today, my lord. It is there today.
Today.
Yes, my lord. This act, my lord, has been struck down. So therefore, the direction to the Deputy Commissioner is to conduct an inquiry under a provision which has been struck down as unconstitutional by this honorable court.
So that petition is pending before Supreme Court.
Supreme Court, yes, my lord.
Against the striking down.
Yes, my
Yes,
lord.
my lord.
Striking down order.
Yes, please, my lord. The entire act has been struck down as unconstitutional. So therefore, my lord, question of now Special Deputy Commissioner now holding an inquiry under an act that has been struck down at all, my lord.
You produce the order of.
Yes, my lord, it is produced. My lord, it's produced. I'll also, my lord, my lord, please. Please have a look, my lord.
They have gone against the Supreme Court.
The state, my lord, has gone to the Supreme Court against the striking down of the act.
And
it is pending there.
There is a stay of the order.
There is a stay of the order.
Then
That is
Then, my
recorded
lord,
in
That is clarified, my lord. Please have a look at this, my lord, division bench. There, my lord, when there was a stay, the state legislature, my lord, amended the act. That has again been struck down by this honorable court. Please have a look at this judgment, my lord, in Mahaganapati's case.
Justice Bopana,
Sorry, my lord.
Justice Bopana.
No, my lord, this is, my lord, Justice Anand Bhaira Reddy and Justice Sujata. The original act, my lord, was struck down. There is an amending act. Amending act has also been struck down. Therefore, my lord, the 2011 and 2012 Amendment Act has also been struck down. And this is pending before the Supreme Court. As against this, my lord, there is no stay order.
But now the order of striking down have been stayed by the Supreme.
No, my lord, this order is not stayed. That is original act, my lord, was struck down, that was stayed. Then, my lord, the state legislature brought about the 2011 and 12 Amendment Act. My lord, they went back to the Supreme Court and said when the matter is seized before the Supreme Court, they could not have brought the Amendment Act. What the Supreme Court said was, let it be, my lord, decided by the High Court. Now, my lord, 2011-12 Act has been struck down by as unconstitutional, my lord, in this Mahaganapati Shankara's case. Now, this has been taken to the Supreme Court again, but as against this order, my lord, there is no.
Which order?
This order, my lord, what my lords are now referring to in Mahaganapati's case. Yes, my lord, that, my lord. There, 2011 and 12 Amendment Act to Section 25 has been struck down.
What was that amendment?
Sorry, my lord.
What was the 2009 and 11 amendment?
My lord, what happened, my lord, is Section 25 of the Act, my lord, provided for constitution of a management committee for regulating temples.
We'll see this. Come on, when the matter is there for the deputy.
Today, my lord, it
Deputy
is there
Commissioner,
today.
my lord, it was scheduled on 21/10/2024 and thereafter adjourned, my lord. It is
It is
scheduled
there
for
today,
today
my
as
lord.
per
It is
the
there
instruction.
today.
Send over to, today they will not proceed.
Let there be a stay, my lord, because there's a
Lord,
time-bound
the
direction.
interim arrangement, my lord, as per paragraph 12, the interim arrangements to conduct the puja and other rituals, my lord, has been given to respondent number 4, the contesting respondent in the matter.
Lord, that
Proceedings
person,
of DC, my lord, I can instruct them not to precipitate the matter, my lord, before the deputy commissioner at least. I can instruct them not to proceed with the, precipitate the matter till such time the matter is decided by this
Send
honorable
out to
court.
5th of December to be
Very
listed
well.
at 2:30 in learned additional government advocate shall instruct the authority concerned not to precipitate the matter
Very
and
well.
not to pass any order.
very well.
Very well.
I'm grateful, my lord.
Let us understand.
Yes,
Give
my lord.
the-
I'll understand, I'll
give-
produce one synopsis, my lord.
Give,
I'll give a date-wise synopsis so that, my lord, I'm able to explain from date 1 till now what has happened. I'll also place the orders of the apex court, so that, my lord, I'll make a compilation and,
by
give-
day after tomorrow.
my lord, I'll give it, I'll file it in a week's time, my lord. My lords have fixed the date as 5th. Before that, I will file it, my lord. Yes, my lord. I'm grateful, my lord.
Case number 29, Mr. Satish K.
Airport. On matter pertaining to transfer, my lord. My lord, this petitioner is appointed as, my lord, field officer by the university on 18/1/2006 under the central, my lord, scheme called Studying Cost Cultivation Scheme, my lord. Page, my lord, 85 is the appointment order. Kindly see, my lord, appointment order. He is a field officer. Next, page 85, my lord. Vice Chancellor so and so appoint Mr. Jagannath Olekar the post of field officer cost cultivation scheme. In the cost cultivation scheme, my lord, posts are there, entered into memorandum, my lord. Again, my lord, that post was upgraded in the year 2022, and I am continued, my lord, as, my lord, the post of field officer also, my lord. My lord will find the page 100. After upgradation, my lord, that is my lord, equivalent to my lord, associate professor, my lord. Joint duty as, my lord, field officer only in the same scheme, because central government, unless central government, my lord, says, my lord, scheme is finished, transfer, then, my lord, they can do it. Then what happened, my lord, on 31/5/2023, my lord, page 109, my lord, the university transferred me as assistant professor VC for Belgaum, my lord, Mandya. Page, my lord, 112. And it's English translation is there, my lord. As a field officer, I am shifted as, my lord, assistant professor, VC form Belgaum, I mean Mandya. My lord, the central government says, my lord, by annexure G, please don't shift him because he is attached to scheme. And it's annexure G, page 114. In spite of that, my lord, they shifted this code, my lord, annexure H order, quashed the order on the ground. There is no post of associate professor at all. And it's, my lord, page 117, order of this code, quashing that transfer order, my lord. Page 117, my lord. Finding is, my lord, para 5. I don't read entire order, my lord. In the light of the submission made by the learned counsel appearing for the parties on careful examination of the annexure R2, it is reflected there is no sanctioned post of associate professor of agriculture economics at college agriculture VC form Mandya. In that view of the matter, is well established principle law, no transfer will be made by employer to unsanctioned post further transfer of the
You
petitioner.
were posted initially when as associate,
Right.
as associate professor, you were posted where initially?
My lord, page, my lord, initially I was appointed as field officer.
Field officer.
my lord, 85, my lord, page 85. Under the, my lord, a central government scheme. Cost and cultivation scheme, my lord, it is central government scheme, my lord. Can you see that also? Field officer, cost of cultivation scheme, it's mentioned there also, my lord. No, my lord, in spite of quashing the order of transfer, again,
At which place?
page 87, my lord, English.
Which place?
My lord, Bangalore, abroad, Bangalore, my lord, University. Annexure A, page 87. This translation is there, no, typed copy. Vice Chancellor of University Agricultural Science, Bangalore, is pleased to appoint Jagannath Olekar to the post of field officer, cost of cultivation scheme. About 87. On thereafter, my lord, on 2/2/22, I was given a associate professor pay scale by upgrading field officer post. And that also, my lord, annexure D, page 100. Page 100. When things stood thus, my lord, they transferred me from, my lord, post of field officer to that of, my lord, assistant professor on 31/5/23 to VC farm, my lord, Mandya. That was quashed by this court. Page 115, my lord, 117, para 5 is the reason. Reason is, my lord, there was no post of assistant, lord. He was not posted as assistant professor, which is lower grade, and associate professor post is not existing. And you see that also. Because university has filed reply statement stating that, my lord, there is no post of associate professor existing in the VC form Pandya. Page 118 is the reason, my lord. 114 is the order. 117, para 5 is the reasoning. Respondent university cannot post the petitioner to the post, which is below the rank of associate professor, agriculture economics, and though pay scale will be maintained by a respondent university. It is very clear, my lord, from the document produced by the, my lord, university, my lord, post of, my lord, associate professor in VC was not existing at all. Not existing at all. My lord, will get the document produced by them in the previous writ petition, annexure N, page 144. My lord, kindly see the page 144, my lord. Therefore, this court said, you cannot transfer him to the lower post. Passed it. In spite of that, my lord, now one more order is passed on, my lord, 8/7/24, annexure, my lord, P, page 147. 147. That is the impugned order before the learned single judge. Transferring it to the post of professor. 147, my lord. And DC, my lord, 147, my lord. Transfer order. Lord, I am transferred as professor. This I have questioned, my lord, mainly, my lord, mainly on the ground, Lord. There is no post of associate professor. You cannot transfer me to higher post. Because transfer is permissible only equivalent post. Kindly see page 147, my lord. Jagannath Olekar, field officer, associate professor grade, so head cultivation, so and so, is transferred vacant to agriculture economics, professor grade. Professor grade. Page 147. Page 147 is not not English translation is not assistant, not is associate. Field officer is equivalent to associate professor. It's upgraded in 2022. The learned thing the judge not granted interim order. Then Lord dismiss the petition on the ground that no doubt it is a professor post, you go and report duty, higher post. Page 150, Lord, interim order granted by the judge. Finally, my lord, the learned judge dismissed the writ petition on the ground that, my lord, the no doubt there is no post of associate professor. You are posted as a professor. Please go and report duty. Number one, whether, my lord, is it permissible, my lord, to transfer me to the post of professor? Learned judge says, my lord, he is only posted as a associate professor. But however, for the purpose of drawing salary, he is posted there. Order is not otherwise, my lord. Order is very clear, my lord. I was posted as a professor, my lord. But sufficient to your lordship is threefold. Transfer is permissible only equivalent post, either lower or higher. But can the state exploit the blood of me, doing duty of a professor and paying salary of associate professor? But I have hardly experience in teaching, my lord. Certificate is also issued, my lord, by the university. My lord will find that also director head has issued certificate, my lord, and see, my lord, that also. Page, my lord, 1444. Learned judge says, my lord, I have teaching experience. You go. Though you are posted as a professor, yes, you go. Without consultation of the, my lord, central government, it is not permissible. Though I have produced the document, but either you go. Kindly see, page 1444. 444, my lord. Contrary to, my lord, on records.
The transfer, we don't interfere.
Yes, my lord. That's why, my lord, Supreme Court says it's only permissible equivalent post is there.
It is equivalent post, same.
It is not equivalent
Same
post.
pay scales.
No, my lord. Associate professor is higher grade. I can understand, my lord, as associate professor I am posted. No, there is no post of associate professor at all.
Paragraph 15.
Paragraph 15. Yes,
Respondent has certified that the petition is transferred on his own scale. And
no, not own scale, but as a professor.
It's only a designation, otherwise the same.
No, not, that is impermissible because I am holding associate professor, Lord. I cannot be transferred to professor post.
It is higher post.
It cannot. That is why Supreme Court says it is impermissible to post a higher post or lower post, only equivalent post. Kindly see the judgment of Supreme Court, Lord, on the hand. I know, my limited submission in the transfer matter. My lords, you also normally will not transfer, no interference. But case like this, Lord, kindly see, Lord. In the matter of transfer, Supreme Court examined this question whether is it permissible, my lord, to transfer my lord, employee other than the equivalent post is the question.
So first you become field officer, then you are first you are field officer.
I'm a field officer too.
Then you are a teacher.
No,
No?
Field officer only.
When you were transferred, what was the post?
22. 22 my lord, field officer.
When you were transferred, what post you were holding?
Field officer, my lord.
Field officer.
Field officer. Throughout my life, I am field officer, my lord. It is not disputed. Kindly see, my lord.
Here say there is, provided there is a loss of pay, there is no loss of pay.
Right?
There is no loss of
No,
pay.
no, no. Court says, my lord, in that case, my lord, kindly see. Para 15 and lord 17. Para 15 only. Lord, examining this question. Orders of transfer were passed by authority purported to exercise its executive power. Executive power can be exercised only in terms of the extant rules. It is well settled that executive order results civil consequence. Principles of natural justice required to be complied prior thereto. It is not the case where an order of transfer was passed by a change of place of employment within the organization. Simplicity. An order transfer ordinarily should be in terms of the existing rules. Transfer may even incidental to the condition of service, but thereby nobody can be deprived of existing right. Existence of power and an exercise thereof, two different concepts. An executive order in the absence of any statutory rules cannot be exercised, which would result in civil and penal consequences unauthorized for the purpose. An executive order passed for the unauthorized purpose would amount to malice in law. An order of transfer cannot prejudicially affect the status of the employee. If orders of transfer substantially affect the status of the employee, the same would be violative of the condition of service, thus illegal. Transfer must be made to equivalent post.
You already taken charge as the transport.
There is an order of stay. There is an order of stay.
You've taken charge.
Where, bro?
At Monday, you taken charge.
No, bro. There is an order of stay by the one single judge. Can you see that also? During the pendency of the writ petition, there is an order of stay. Otherwise, page 150. I produced that order also. Page 151. It is paid to stay the operational implement of the order funds. Normally, my lord's view is transfer case, no. But case like this, my lord has to examine.
Lord learned responses also. The contention is that the petitioner was and continued as field officer, came to be transferred as professor.
Professor.
To work at the agricultural economic at VC Farm Mandya. The contention is that the transfer of the petitioner is on a non-equivalent post. For such transfer, permissible in law. Notice returnable on 10th December. Interim order which is continued by learner single judge.
Yes, Lord.
Shall continue to operate till the next date.
Annexure P may be stayed, Lord.
No, we are not staying. We are continuing only the order which is passed by learner single. Nothing is stayed.
Yeah.
You are saying that there is an interim order passed
Yes,
by.
Lord.
It is continuing?
Yes.
Till
Till my lord passing of the order. Thereafter, I have not gone. Kindly see kindly appreciate this, Lord. Because.
So you go on leave.
No, I have not gone on leave.
You go.
What Leonard Judge says he
going to stay the. Notice read on 10th.
Lord, interim order is passed. Lord,
Is continued today.
Lord?
Is continued today. Interim order is continuing.
No, Lord. Interim order is terminated after the final order is passed. Lord.
So therefore,
But-
it will be open for the petitioner to proceed on leave.
Right?
You may proceed on leave. We are not staying. Staying will amount to allowing the petition. We'll examine on that.
Yes, my lord. May I make an appeal to your lordship, my lord? Since the salary is not paid, another says don't pay salary unless he is reported duty at Mandya, and it is at all.
We'll see on that the next day. All those questions. About salary, etc.
One date. will
Proceed
give-
on leave.
One date. not one week.
10th December.
Correct.
Commercial appeals, December 30, Mr. Prakash M.
For the respondent.
For the appellant. The respondent filed the application under section 9 of Arbitration Conciliation Act. Said application on allowed on 21st August 2023. The respondent directed the furnished the bank guarantee for rupees 2 crores 17 lakhs 10,168. The brief facts, the appellant and respondent, the executed lease agreement in the year 2018 and 2019 lease agreement and commence on 1/1/2020. The position taken in the year 2020. After the taken position, 3 months only, the position. Then after the COVID-19, the appellant hand over the position to the respondent in the month of March. The respondent not given any acknowledgement on the receipt. And also myself, the respondent filed the arbitration clause. Appellant and respondent will close friends, my lord. And 3 months, my lord, the rent already given, pay the amount, my lord.
Arbitration clause in invoked or not invoked?
Not, I have invoked. CMP, I am unable to serve notice to my learned friend.
Notice is served.
Notice is not been served, please. my
Not
lord.
served.
Not served. I take notice to my learned friend, he doesn't appear to the court also.
No, arbitration clause is invoked, not.
Yes, my lord, arbitration clause is invoked. I have filed a CMP also. I am unable to serve the notice to the appellant, nor to my learned friend. my lord. And the arrears of rent is as on date is 4 crores, please. my lord.
So it is a dispute about payment of rent.
Please,
my
my lord.
The lease agreement, my lord, 1/1/2020.
So what is wrong in
After
it?
the 3 months, my lord, the
This
COVID.
2 crores 70 lakh
lakhs.
represents what amount?
That was as on the date of the order passed by the trial court, please.
No,
my lord.
that was, it represents what amount?
It's
Rent?
a rental, sir.
Arrears
rental.
of rent.
Arrears of rent.
Where is that? Yes, what do you say?
My
What
lord,
is the
the-
ground?
After the 3 months, my lord, the appellant, my lord, hand over the position to the respondent, my lord, in the month of March 2020, my lord. The respondent not any given acknowledgement and receipt, my lord, by the respondent, my lord.
Pardon?
The 2020, my lord, the lease agreement dated 1/1/2020, my lord. After the 3 months, my lord, the 3 month rent already given, my lord.
What are you doing?
After the COVID-19, my lord,
What are you doing in life?
my lord, The
What are you doing in life? You are a businessman or serviceman or what?
businessman,
What business you are doing?
it's a construction building, madam.
Construction. And you had taken this premises on rent.
Respondent, my
He has
lord,
demolished my building also. And he has not even put up construction. He says he has surrendered possession, there is
Now
no.
this 2,70,000 about the, how it is arrived at amount
Not 6,49,000 is the rent per month.
and interest.
And it is, he has not paid a single day also, please.
5,50,000 per month rent, my lord.
That was
At
the
the time of
initial
the rent, lease agreement date.
And the lease deed
Only,
says,
my lord, 3
Lease,
months,
lease subsist
lease,
or lease are expired?
lease has expired.
2009, 29, my lord.
Lease is still there,
9 years, my lord.
Lease continues.
continues.
No, my lord. Only 3 months, my lord, only vacate, taken the position, my lord.
Period of lease continues.
28 minutes, 30.
They are occupying the premises or vacated.
Vacated, my lord. In the month March 2020, I am vacated the,
When you are vacated?
March 2020, my lord.
March 2020.
20, my lord.
And you have not paid anything towards that.
No, my lord.
So why should we interfere? Prima facie case is made out.
He says he has vacated.
Ultimately, this has order 39 rule 1 principles to apply in section 9 application. He has surrendered the possession.
No, my lord, he has not surrendered. He is orally plead surrender.
Orally, my
A
lord.
registered lease has to
But
get
the
surrendered
respondent
only
not
by
given any
registering a
single
deed of
receipt
surrender
and
only.
acknowledgement, my lord. The respondent applied with the close friends, my lord.
Very good.
What is the ground of not paying the rent?
5,50,000 per month, my lord, at the time of the lease agreement, my lord.
What is the ground of not paying the rent?
2 months, my lord, rent I will give. 2 months, my lord.
Why you are not paying the rent? What is your defense in the other words? What is your defense for not paying the rent? Otherwise, we are not interfering. You must have some defense, valid defense. Prima facie defense. That is worst. Page 15. Page 15, on issuance of notice, the respondent appeared through counsel. Not at all resisted this filing. So no statement of objection was filed. What can we do now? Yes, Mr. He is raising the defense of COVID. This was rented for what purpose?
Lord, he had to put up a commercial building.
Commercial building.
Yes, please.
Land was rented.
No, I had an old structure which was in existence that he demolished and he wanted to put up a commercial
The
building.
construction is complete or not complete?
He has not even started the building construction. He has demolished the old structure also. I'm at loss, even that old structure, I am not able to secure it back.
coincided the COVID period?
Not, had he paid 1 month rent at least, my lord, some consideration could have been given. A check is issued for 1 crore, that is also bounced as account blocked.
Check is bounced.
Yes, please, my lord, I filed 138 proceeding. I have filed 138 proceedings, which is still pending.
So place that on record.
Please.
Place the, otherwise you are thinking of reducing some amount of bank guarantee.
Not, I will not recover anything from him because, my lord, I shall place that record, please.
Because the defense appears to be of COVID period.
Certainly, had he paid at least 1 month rent, my lord, I could have
Not a
considered.
single month rent.
Not a single month.
Place that on record then.
Please.
On fifth we'll take up. You have no case, Mr. No case earlier, no case in the trial court, no case here. Just standing without speaking any. Fifth will take up, fifth. You terminated the.
I have terminated, but I am unable to file ejectment because arbitration clause is there. CMP is filed, it is pending, I am unable to serve notice today. I am stuck on all sides, please, Lord. Neither I am receiving rents nor possession of the property.
We'll put an end on fifth. There is no case. Let us see what the, something can be. Pursued your learner friend. Fifth.
Oh, bless.
Number 31, Girish Kumar BM.
Listed 230. This may be listed at 230.
On behalf of the appellant.
Responded.
Defendant's appeal arising out of an application under section 8, which has been rejected by the commercial court. Plaintiff filed a suit for recovery of certain amount. Plaintiff and defendant are partners in a partnership firm. The partnership deed has an arbitration clause. There is a dispute where he raises a claim against me saying that I
What
hold.
ground it is rejected?
On the ground that apparently I had entered into an agreement with him subsequently saying that, yes, we have differences. I'll pay you certain amount. That agreement does not contain an arbitration clause. There is no dispute. And therefore the agreement, the application is rejected is what the trial court says. The partnership is not terminated. The partnership is still in subsistence.
Where is the prayer in the suit? Let us see. Prayer in the suit.
Pardon.
Plaint is there.
Well, at page 25.
Page 20. Plaint is at page 20.
Plaint begins at 22.
Plaint
The
begins.
plain simpliciter. Plaint begins at page 22. madam. At 25 on top. Simpliciter claim for recovery of money. In fact, it begins on the statement that we are partners, para 2.
So separate agreement for settlement was entered in.
That's right.
Yes, ma'am.
Separate agreement
That's right.
for settlement.
That's right.
So regarding the
Some amount that.
mode of payment.
Yes,
Mode
my
of
lord.
payment.
Mode
Well,
of payment.
basically, it was originally my business. I was running the business. He came in as an investor. In fact, the two agreements are not part of the memorandum of appeal. They have been produced lately. My lord, may I just?
So according to you, this will fall under first agreement,
This will, well, the first agreement has not been terminated.
plea agreement.
This is only the partnership deed is the only deed that binds us. What I have agreed to repay to him is only a part of the understanding between partners. It is his claim also that this is a partnership dispute by the very reason that the suit has been filed as a commercial suit. A dispute arising out of a partnership deed is a commercial suit. If it were filed under the subsequent agreement, which he contends is a separate agreement, it would not be a commercial suit in the first place. So it is the plaintiff's own understanding that is a dispute arising between partners. In the plaint also, he begins the plaint by saying we are partners. So it is a self-contradicting argument by the plaintiff to say that it is a claim arising out of the subsequent, because if it is a claim arising out of the subsequent agreement, you would not have filed it as a commercial suit, because it is not maintainable as a commercial dispute.
Commercial suit is filed.
Commercial suit is filed.
This is commercial.
This is a commercial suit. So it is primarily a dispute between partners. Anyway, also, my lord, the position of law in Magma leasing, I produced it. The position is this: even assuming, though it is not anybody's case, even assuming that the partnership deed has come to an end and subsequently there is some understanding between partners, the arbitration clause continues to subsist. So if there is a dispute,
So there is independent contract.
that is a law. So in any event, we are bound to go for arbitration only.
So this due arises out of some partnership transaction.
Partnership transaction. What had happened, and the partnership deed is produced separately, my lord. What was going on was I was running the business. He came in as an investor and said, I will invest X amount of money. You may retain the amount for 5 years, and thereafter we will work out the arrangement for profit, etc. In between, he changed his mind and said, no, I want my money back urgently. So I said, all right, here is an understanding between us. This is the manner in which I'll repay your money. But the partnership did not come to an end. The agreement, in fact, says after the money transaction is over, then the partnership will come to an end. Well, in fact, I have also submitted a synopsis which may assist the court.
So you have to show that the arbitration clause in the partnership agreement could be read into this agreement.
That's right. That's right.
So judgments are there on these lines.
I have submitted a synopsis on 21st March, brief facts as well as 2 decisions of the Honorable Supreme Court. One on the proposition that when Section 8 is urged before a court, a trial need not be conducted. If the court finds that there is some agreement between the two of you where there is an arbitration agreement, then the court is required to refer us to arbitration. It is only a prima facie case that I have to make out before the court.
Nexus has to be.
That's that. That nexus is to be seen in the second decision, Magma leasing, where the Supreme Court says, assuming that there is an agreement which has come to an end, but if that agreement contains an arbitration clause, any dispute arising out of that same relationship, then that will also go for arbitration. I have produced it in my sign-off.
Even if the agreement is over.
Is terminated.
Terminated.
That's Even if the agreement comes to an end, the words they use is in respect of, with regard to, or under. So in respect of that partnership, only that agreement was there. So my synopsis, if I may take your lordships through the dates. 24th June 2020, we entered into a partnership. Clause 21 of the partnership deed provides for arbitration. In my synopsis, my lord.
Where you are?
Well, at the first page, the dates.
Here.
24th June 2020, partnership deed. 21 of that partnership deed provides for arbitration. 10th August 2022, due to differences between the partners, the parties allegedly entered into an agreement under which the respondent agreed to exit from the partnership upon or after receipt of some money from the appellant. 3rd August 2023, the respondent filed a commercial suit, OS number so-and-so in the Honorable Commercial Court, Mysuru, seeking recovery of money from the appellant. 5th September, I filed my application under Section 8. 20th September, he filed his objections, contending, my lord, not that this is not applicable, arbitration is not, he does not contend that. He simply files objection saying, there is no dispute. That kind of, the dispute is there. 20th January is the impugned order, and I present this appeal, my lord. The first proposition that I'm urging in this appeal is, commercial suit has been filed as a dispute arising out of a partnership agreement. It is his own case, because under Section 2(1) of the Commercial Courts Act, it is provided that a dispute between partners to a partnership agreement is a commercial dispute. If you only have come to a commercial court, then it is your own case that is a dispute between partners. Because if the dispute were arising out of the subsequent agreement, it is an ordinary agreement between two persons for payment of money. That would not be a commercial suit. You would have had to file it before a regular court. That you have not done. That is the first proposition. Right? Second proposition is
Very suit and the nature of suit and the dispute raised in the suit is referable to the original agreement.
That's precise. Para 2 of the plaint also starts only on that basis that we are partners.
Yes. Then.
And my lord, the partnership deed has not been terminated yet. The partnership is still in subsistence. This, my lord, just two decisions I'll refer to, my lord, at ink page 5 of my synopsis, 2021 5 SCC 671, Praveen Electricals. What is the nature of or extent of inquiry that a trial court is required to conduct when dealing with a Section 8 application? Prima facie.
This Praveen Electricals.
Praveen Electricals at ink page 5. All right, here at ink page 25, para 15, ink page 25, para 15, what is the extent of prima facie examination?
Para
15, 1-5, ink page 25.
Page 25. Oh.
Para 1-5. Dealing with prima facie, my lord, has that? Dealing with prima facie examination under Section 8 as amended, the court then held in Vidya Drolia's case. Prima facie examination is not full review, but a primary first review to weed out manifestly and ex facie non-existent and invalid arbitration agreements and non-arbitrable disputes. The prima facie review at the reference stage is to cut the deadwood and trim off the side branches in straightforward cases where dismissal is barefaced and pellucid, and when on the facts and law, the litigation must stop at the first stage. Only when the court is certain that no valid arbitration agreement exists or the dispute subject matter are not arbitrable, the application under Section 8 would be rejected. At this stage, the court should not get lost in thickets and decide debatable questions of fact. Referral proceedings are preliminary and summary and not a mini trial. This necessarily reflects on
so late. You have to show that the arbitration clause in the partnership agreement can be stretched to the subsequent settlement agreement.
And for that, my lord, to urge that proposition, ink page 39
can be extended to the subsequent.
That's it. That extension can be seen by the law settled in Magma leasing at ink page 39. Ink page 39. Para 1 at ink page 40, this very issue fell for consideration before the Honorable Supreme Court. That when one agreement is terminated and an arrangement is put into place, whether the arbitration in the previous agreement will continue to subsist or not. Para page 40, para 1, the core question that falls to be determined in this appeal by special leave is, does the arbitration agreement survive for the purpose of resolution of disputes arising under or in connection with the contract, even if its performance has come to an end on account of termination due to breach? But in the facts of our case, termination has not even occurred. This is answered at ink page 49, para 14. Ink page 49, para 14. The statement of law expounded by Viscount Simon in Heyman's case, as noticed above, in our view, equally applies to the situation where the contract is terminated by one party on account of the breach committed by the other, particularly in a case where the clause is framed in wide and general terms. Merely because a contract has come to an end by its termination due to breach, the arbitration clause does not get perished, nor is rendered inoperative. Rather, it survives for resolution of disputes arising in respect of or with regard to or under the contract.
Where is the agreement? Press
My lord, the agreement was produced by way of a separate memo dated 14th February. Two agreements were provided. It says memo along with documents. February, man. The partnership deed is dated 24th June 2020. The arbitration clause is at page 15.
No, we want to see the
subsequent agreement.
Yes.
Well, subsequent agreement is at
page 20.
page 20. Nowhere does this agreement provide for termination or cessation of the partnership. But if I may be allowed to read at page 21, whereas the first party and second party herein had entered into a deed of partnership on 24th June 2020 at Mysore City in the name and style of so-and-so having firm number so-and-so by the office of the Registrar of Firms, Mysore. Whereas, meanwhile, Lord will take note of the fact, meanwhile, the first party and second party entered into a MOU dated 10/1/2020. The first party has not fulfilled his words conditions as per partnership deed and memorandum of understanding between first and second party. Now, both the parties have decided that they will exit from the partnership upon the first party fulfilling the terms and conditions as mutually agreed amongst themselves and reduced herein below. First party is me, madam. First party has agreed to pay a sum of rupees so-and-so to the second party on or before so-and-so date in the following manner, but there are certain installments that I have agreed to pay. But at ink page 23, para 6.
Now, what is the dues? This due is what?
Well, a due is refund of the investment that he had made in my partnership, in my business. When he entered into a partnership with me, that can be seen, my lord, at ink page 6. He had invested certain amounts in my business. He says, now I'm no longer wanting to run the business with you. I want to exit. So I said, all right, I'll return your money.
So we'll continue after recess.
Please, Milo.
Lord,
We'll continue.
Great.
Lord, with kind permission, Lord. And submission, Lord. Serial list number 2, serial number 10, Lord. I'm filing memo for withdrawal.
10.
10.
Learned advocate.
Contempt number 452 up to and 23.
Memo, ECC 452. Learned advocate, Use Kayas,
My Lord,
Yes,
with
Lord.
kind
Sab BG, files memo, dated 19/11/24, seeks to withdraw the contempt proceedings. Memo is taken record, dismissed as withdrawn.
Much. My Lord, with kind permission, serial number 101. Did we take it up at?
We'll see, we have said no in the morning. We'll continue, we'll consider. We are in the midst of the hearing of a matter, yes.
My lordship, serial number 60, my lordship, say, list number 1. And short adjournment.
Take the date, after 10th December.
Oh, bless.
Interesting. Hello, sir. Gulbarga bench in the.
Hello.
Sir, Gulbarga bench the audio video clear the sir.
Sir, clear.
Okay, sir. Okay, release it. Mic ಹತ್ತು. ಇಲ್ಲ, ಆಮೇಲೆ off ಮಾಡು. ಇದು ಬೇಕು ಮಾಡು.
Hello, sir. Kotal, sir, Kotal on Kotap, sir. Sir, Kalburgi bench idda?
ಹೌದು.
Kotap, sir.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಇದು RP ಇದೆಯಲ್ಲ ಗುಲ್ಬರ್ಗ ಬೆಂಚ್,
ಹೌದು ಕನೆಕ್ಟ್. ಹೌದು ಸರ್.
ಅದೇ ಯಾವಾಗ ಕರೀತಾರೆ ಮೇಡಮ್?
ಸರ್ ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಕರೀತಾರೆ.
ಹಾ.
Correct answer.
Off ಮಾಡಿದ್ದಾರೆ.
Says review petition, seal number 1, by state.
Which one? This one. Brother, they are withdrawing.
Yes.
Review petition number 105/2024. Figures on record. Memo dated 19/9/24, filed by learned additional government advocate Miss Sweta Krishnappa. Proofs of learned additional government advocate Mr. Jafar FES to submit that in the memo. The review petition may be permitted to withdraw inasmuch as the state of Karnataka has filed special leave petition. Already filed before the Supreme Court in Honorable Supreme Court of India. Honorable Supreme Court. In view of the memo, dismissed as withdrawn.
Seal number 2, RP 89/24.
Alert, sir.
Vijay Kumar K.
2, 3, 4, 5. Memo, the memo, withdrawal is permitted and dismissed as withdrawn.
Plus 2, 3, 4, 5. We may be permitted to withdraw the review petition in view of the state government filed a SLP minutes. It's coming up on 22nd and contentions may be left open.
Figures on record. So there also we have to write in the earlier matter. All contentions are kept open. Like earlier order. All contentions. This court has not gone into merits of the case of the other side in view of the withdrawal of the review. Then this review petition number 89, seal number 2. Figures on record. Memo dated 16/11/24, filed by learned advocate for the petitioner. So and so and so. Memo reads as under. Quote the memo. Of the memo, permission to withdraw. The review petition is granted, dismissed as withdrawn. Then same sentence. This court has not gone into the merits.
Number 3.
In fact, the state government was refused to hear the matter there because of the review pending. Therefore, we have to file our.
The same matter, contempt, if your lordships are aware, where the learned AG had appeared. Their contempt, they said that they have filed a review petition. Then subsequently, my lord, the SLP, and there before the Honorable Supreme Court, a question was put forth as to whether the review has been so that's why last Thursday it was there. Now it is listed on Friday. That's why now immediately they moved to withdraw it.
They have committed.
Yes,
They have committed before the Supreme Court to withdraw. So any other withdrawal?
Similarly, question serial number 7, 8, 9, and 10, 11.
7,
7, 8,
Hmm.
9, 10, 11.
Hmm.
Am I able to permit to withdraw with liberty to seek contempt? Memo.
Six is not good.
By file.
Memo. I'll file the memo. I'll be filing memo.
Filed then, what is the memo? You filed it or not filed?
Not yet filed. I'll be filing now.
Give
I'll need to file by end of this, please.
give copy. You give copy. If it is ready, give copy, we will take.
It's not ready, sir. I'll just file it. It's not ready as yet. It's not ready as yet. I'll just.
Then withdraw without memo. I have no. Make a statement, we'll record a statement.
Yes.
What statement you are making?
Liberty to withdraw with seeking our contentions open before the Supreme Court.
Serial number 7. Learned advocate, Mr.
7, 8, 9, 10, and 11.
Learned advocate, Mr.
Mithun.
Mithun GA. 6, permission to withdraw the present review petition on the ground that the state is same,
Please, my lords.
on the ground that the state has filed review petitions.
SLP, your lords.
Sorry, SLP before this.
Honorable, please.
Permission as prayed for to withdraw the review petition is granted. Dismissed as withdrawn. Then same sentence, this court has not accepted. At this stage, learned advocate for the review petitioner submitted that he may be permitted to file a written memo seeking withdrawal. If such memo is filed in course of the day, the registry
Will file it.
registry will accept.
With
Today
all
you have-
contentions.
Today you have to file.
Please now. With all
So
contentions.
same order in 8,
8, 9, 10, and 11.
9.
Liberty with all contentions left open. Liberty, your lords.
We have said we have not gone into merits.
Yes.
Please,
Same thing.
please.
I think only 6 may remain. I don't know, nobody has made a mention.
I
but
appear for
there
the
one of
petitioners in the
purchases
6th,
are
my lord.
open.
Number
Lord, I
6.
appear, please, my lord.
Precisely.
Lord, I appear for the petition in serial number 6, my lord. I have filed my NOC Wakalat also. Only seek a week's time for lordship's consideration. I'll take instructions and I'll submit before lordship.
It is all connected.
Yes, Lord, because in
All
fact,
arising
one
of the
of
same order.
purchasers had filed an SLP. That SLP has been dismissed by order dated 24/4/24. He is also one of the purchasers. So nothing will survive in that also.
Lord, I have not, I'm not a party in the SLP because I have not challenged the SLP, but I'm just a party in the SLP.
You are there before the Supreme Court, Mr. Counsel.
Lord, I was only a respondent. That's my instruction is that I was a respondent there, but I have not filed any appeal challenging the order. I'm before lordship filing the RP, but the earlier advocate has filed the RP, my lord. He has also not given me papers also. That's why only seeking lordship's kind consideration, only short
It is
accommodation.
arising out of same order.
Same order.
Same.
All are common order.
Yes.
It stands withdrawn.
Please.
Well, kindly have it.
It stands withdrawn, but ultimately you have to withdraw it.
Yes, and ultimately, my lord, whatever happens for the government's thing there in the SLP, that
That will prevail.
You can take
Lord,
your
my-
own call. No, not difficult.
My lord, after 2 days, my lordship may only accommodate me for 2 days, my lord, because without instruction, my lord, it will be difficult for me to make submission. Only
Very,
request.
very well. So that is all.
public.
Please, grateful, great.
Cell number 31, Mr. Girish Kumar BM.
Give me this. We were seeing that subsequent agreement.
That's right, my lord.
Now there, where is that page?
Well, at page 20 of that memo.
20.
Dated 14. Now, before we come to that, my lord, why that second agreement came to into existence can be seen at page 6. Page 4 is the partnership deed clause 5.
Memo dated?
Memo dated 14/2/2024.
Yes, 14.
Memo with documents. My lord, we'll see page 4 first. Why that agreement came into existence. Page 4, clause 5. Refundable security deposit. The first partner, that is I. First partner has demanded a security deposit from the second partner as a condition precedent to the partnership and to retain the goodwill of the business and performance of the second partner for a period of 5 years, starting from the commencement of this partnership deed, that is 24/6/2020. Both parties mutually agree to retain the deposit for a period of 5 years from the date of commencement of this contract or with respective date from the receipt mentioned in clause 6G. At page 6, my lord, the amounts are mentioned. He has paid me 2 crores 25 lakhs at page 6. This amount, he wanted it earlier. I was supposed to retain it for 5 years. He then said that I no longer want to continue in this business, so I want the money back. That is the context for entering into this agreement at page 20, where I say, all right, if you want the money back, I'll give the money back to you. After I give the money back to you, we will terminate our partnership. This second agreement is not a novation of the partnership deed.
No, certainly not the novation of the
That's
partnership.
it is not.
Is a novation in itself, novatio in itself or not?
Correct. Therefore, the partnership continues to subsist. The clause 21 at page 15.
If agreement is a novatio in itself, may not be extension or may not be novatio of partnership.
Correct.
But otherwise novatio in itself.
No, a novation necessarily means
separate agreement.
Well, a novation necessarily means a change of the terms, change of the relationship. Relationship does not change. We still remain partners. And in our agreement at page 21,
Page 21.
Page 20, it begins. The recitals are at page 21.
Yes. So essentially, this is an agreement for rearranging the time.
For me to return the money, rearranging the amount. I was supposed to have kept the money for 5 years.
You are returning the money.
I am returning the money to. I am the first partner. Originally, it was my business. He is the investor. He came in, gave me money. Now he has changed his mind. He says, I want my money back. I have agreed to give him the money back according to him, this agreement. I am not admitting this agreement.
And your application for under section 8?
I have filed the application saying that if there is a claim against me which I am disputing, then the remedy under the contract that binds us is arbitration. You have to go for arbitration. And as I began in the beginning, my submission was, it is his own case that is a partnership dispute. That is why he has approached the commercial court.
That you submitted.
Right. And the two decisions my lord has seen. One, that the scope of inquiry for a consideration of section 8 is only a prima facie examination.
You have paid any amount or not?
I have not paid. I am disputing this agreement.
You're disputing the agreement?
The second agreement. Those are my instructions, my lord. It's going on in Mysore. I am not on record. So
disputing in the sense?
No such he says that liability does not arise under that agreement is what the instructions are. But we have not yet reached that stage as of now.
If you're disputing with the very agreement, then your whole premises falls down.
Like I said, that comes separately. That will come subsequently, not at this stage.
We understand, but you're disowning the agreement.
Is my instructions. The second agreement.
Not entered into it all.
Is what I'm being told now.
then you should take illegal action instead of filing section 8 application.
No.
Your conduct of filing section 8 application and your stand that we are disowning the agreement doesn't go together.
No, it does. For the reason, section 8 is based on the partnership deed. I'm not disowning the partnership deed. I'm disowning the 10th August agreement. There is no arbitration in that 10th August agreement.
Where you disown the agreement?
No, like I said, it has not yet, these are not instructions now. It has not yet come into the pleadings. We have not yet reached that stage.
It has not come in pleading.
We have not yet reached that stage where there is a necessity to determine my liability.
Then forget.
Then we will not go into that. That's what I said.
Otherwise, it will be charting to a different road.
That's right. We have not reached that stage.
Thoughts at least in our mind. Yes.
Yes, my lord. They never disputed the execution of this agreement, my lord. I had issued a notice on 24/2023 to him.
There is one more thing which is there any effect of this clause number 6 on your writer's?
If the first part, in the second agreement,
yes.
if the first party has failed to fulfill the conditions of this agreement, that the second party is entitled to specifically enforce this agreement under the provisions of the Specific Relief Act 1963 before the competent authority court. Makes no difference. The point is, even if he seeks enforcement of my obligation under this agreement, he needs to go for arbitration because the amount that I have to pay is arising out of the partnership.
This suit is the fallout of this clause 6.
The suit that
Clause 6 only has filed the suit.
Yes.
Clause 6, he has filed a suit. He has filed a suit under clause 6, but having filed it as a commercial suit, partnership dispute. Because as I said in the Supreme Court says, if the dispute touches upon or in concern with or with regard to, here the amount that I have received is with regard to the partnership dispute. In the partnership, you brought the amount, I have to return the amount.
What do you say?
They have not disputed this execution of this agreement, my lord. Or it's first time now they are saying that we may dispute it. I had issued a notice to him on 24/2023 and also 28/4/2023 rejoinder. For that, they have not replied. After that only I filed the suit. In the suit, they come up with this application. They never disputed the execution of the agreement. In the agreement, it has been specifically mentioned that they have to refund the money, whatever I have invested, along with the damages. He has agreed for that. And he has executed that agreement. And in that, clause 6(4) is very clear, my lord. It is further agreed that irrespective of profit or loss of the partnership, the first party shall pay the second party the amount as agreed herein in full and final settlement. And next, clause 6, if the party fails, if the first party failed to fulfill the condition of this agreement, that the second party is entitled to specifically enforce this agreement under the provisions of Specific Relief Act before the competent authority or court. As per that, I filed a suit. I am not disputing the partnership deed. There is no dispute between us regarding that partnership deed also, or any clauses in that. Now we have agreed everything. He asked me to go out of the firm. I have agreed that. Both the parties have come to a consensus and have entered into this agreement. As per this agreement, I have agreed to receive that much amount from him. There is no dispute between us. If there is any dispute, you ought to have issued a legal notice or you ought to have filed a suit.
That doesn't answer their contention.
That they have not taken any action till today. Even if if I have created this agreement, they ought to have given a complaint or they have to take any legal action. They have not done that. They are aware of this agreement.
So they are saying that notwithstanding the subsequent agreement, your arbitration clause would
Arbitration clause is not there in the subsequent agreement below.
survive because
it will survive if there is any dispute between the parties in respect of anything in the partnership. There is no dispute regarding the partnership.
there is a dispute. Whole substratum is partnership dispute.
No, my lord.
That is what they argue.
No, there is they are arguing that, but there is nothing on writing.
No, the very amount payable and the liability is the partnership Debt.
So they have admitted the receipt of that amount and they have not disputed the execution of this
It is a
agreement.
different thing that we are not going in.
No, that's what I'm,
Judgment
prima
is-
facie, no, the prima facie, they ought to have proved that that agreement has been created or something like that. When they have admitted that execution of that agreement, when they have not disputed the execution of that agreement, the nothing remains for deciding by the arbitrator, my lord. Even in the affidavit filed along with the application, they have not stated anything about that. Even the dispute also, nothing they have mentioned. They simply said that in the partnership deed, there is an arbitration clause, so it has to be decided by the arbitrator. They have not disputed till today anything. On the other hand, he sought time for payment of the amount as per the agreement. Till today, he has not stated anything. What is the dispute between us? Nothing he has stated.
Your arbitration clause in the main agreement, partnership agreement, says that
Interpretation of clauses. If there is a dispute between the parties, interpretation of clauses.
that is what we are asking.
Yes, below.
That if any dispute
Would
would arise,
interpretation of any clause of the.
if any dispute would arise in interpretation of any of the clause of this deed, the same shall be referred to the arbitrators in accordance with the Arbitration Act and shall be finally made.
It is limited in that sense.
Yes,
That's right.
there is no dispute between
the-
us regarding that.
The clause for interpretation would be my requirement to retain the deposit for 5 years or to return the amount earlier. That is the clause here, which is a dispute between us now. That's why I read out the first clause. As soon as I began my submissions in the afternoon now.
That clause occurs in the subsequent agreement, not
That's
in
right.
this agreement.
No. The agreement here is at ink page 4. That is where I began, my lord, today. The first partner has demanded a security deposit from the second partner as a condition precedent to the partnership and to retain the goodwill of the business and performance of the second partner for a period of 5 years from the commencement. This clause entitles me to retain the amount for 5 years. I am now saying that I don't have to return the money. I am disputing my obligation to return the money. This is what will fall for adjudication. He has a claim against me. I am disputing that claim.
Which clause falls for adjudication?
My lord, this clause at ink page 4, part of clause 5, although it is not numbered separately, it is supposed to be clause 6. Refundable security deposit, because that is the amount that he is seeking back. The amount that he is seeking back is this. When he came into business with me, he gave me this amount saying that I can keep it for 5 years. Now he's saying I want it earlier. There is a dispute.
You have both of you have walked out of this clause by entering into a separate
agreement.
That is what falls for adjudication. We are going ahead of the issue. The issue is which is the forum that has to adjudicate upon this. If the forum has to be an arbitral tribunal, according to us, because the dispute arises out of the partnership deed. If, my lord, as my learned friend is contending, no, it has nothing to do with the partnership deed, it has to do with the subsequent agreement, then in that case, the suit itself is not maintainable before the commercial court. Because this is not a commercial dispute.
I am relying upon certain judgments, my lord. The first judgment, my lord. When the parties have entered into a settlement, then they can't say that in the original agreement there is an arbitration clause. Page number 2, my lord, ink page number 2. From the bottom. Eighth line, my lord. Even otherwise, we feel that once
Where you are reading?
page number 2, my lord. From the bottom, eighth line, my lord. Even otherwise.
We feel that. Even otherwise, we feel that.
Please, my lord.
Even otherwise, we feel that once the party.
Please, my lord.
Yes.
Even otherwise, we feel that once the parties have arrived at a settlement in respect of any dispute or difference arising under a contract, and that dispute or the difference is amicably settled by way of final settlement by and between the parties, unless that settlement is set aside in proper proceedings, it cannot lie in the mouth of one of the parties to the settlement to spurn it on the ground that it was a mistake and proceed to invoke the arbitration clause. If this is permitted, the sanctity of contract, the settlement also being a contract, would be wholly lost, and it would be open to one party to take the benefit under the settlement and then to question the same on the ground of mistake without having the settlement set aside. In the circumstance, we think that in the instead cases, the dispute or difference was finally settled and payment were made as per the settlement.
Yes. Yes, then.
So it cannot be reopened, saying that there is an arbitration clause in the earlier agreement. And second judgment, my lord, AIR 2018 Supreme Court 796.
796, yes.
Para number 23, my lord, is in page number, ink page number 15. Para 23 onwards, my lord.
23 onwards.
Pursuant to the taking of a false claim of duress and coercion while
Page
page 15, page 15, my lord.
50.
15.
Oh, from the material, yes. Read it.
Pursuant to taking a false claim of duress and coercion while filing the no due certificate, the contracting company wide letter dated 12/1/13 to the appellant contractor submitted a claim for rupees 96 crores for the loss incurred during the execution of the contract at Mangalore. It has been claimed that the contracting company could not continue with the work due to various reasons like puja, shifting, issues with respect to the work to be given to the local contractors, non-vacation of projects. And in continue, para 24, my lord.
23, there is nothing.
23, they have stated that regarding dispute everything. And next, para 24. From the materials on record, we find that the contracting company had issued the no due certificate or no claim certificate. It had received the full amount of the final bill. Thereafter, and we also find that the final bill has been mutually signed by both the parties to the contract, accepting the quantum of work done, conducting final measurements as per the contract, arriving at the final value of work, the payments made, and the final payment that was required to be made. The contracting company accepted the final payment in full and final satisfaction of all its claims. We are of the considered opinion that in the present facts and secondary case, the raising of the final bill and mutual agreement of the parties in that regard, all the claims, rights, and obligations of the parties merge with the final bill, and nothing further remains to be done. Further, the apparent contract issued the completion certificate dated 19/6/2013, pursuant to which the apparent contractor has been discharged of all the liabilities. With regard to the issue that the no due certificate has been issued under duress and coercion, we are of the opinion that there is nothing on record to prove that the said certificate has been given under duress or coercion, and as the certificate itself provided a clearance of no dues, the contractor could not now turn around say that any further payment was still due on account of losses incurred during the execution of the contract. The story about duress was an afterthought in the background, that the losses incurred during the execution of the contract were not visualized either earlier by the contracting. As to financial duress or coercion, nothing of this kind is established prima facie.
mere allegation that no claim certificate have been obtained under financial duress and coercion without there being anything more to suggest that does not lead to an arbitrable dispute. The conduct of the contract clearly shows that no claim certificate was given by it voluntarily. The contractee accepted the amount voluntarily and the contract was discharged voluntarily. So there is no arbitrable dispute. And next judgment, my lord. AR 2023 Supreme Court 1654. That para number 17, 18, 19, and 20, my lord.
Para number?
Para number 17, 18, 19. I have mentioned in that list of citations. In the list itself, I have mentioned that para.
Where you
numbers.
mentioned?
First page, list of citations.
List. Okay.
It's in page number 34, my lord, ink page. The efforts may I read it, para 17, 17.1. Ink page number 34, my lord. Finally, they have mentioned para 20, my lord. For what has been discussed in above on the facts and in the circumstances of the present case and in the nature of transactions as also the nature of reliefs claimed in the suit, the view taken by the commercial court and the high court in declining the prayer of the appellant for reference to arbitration cannot be faulted.
So here, what was the facts? Tri-party agreement was executed.
In that, they have claimed that without relying upon the original agreement, based on this tripartite agreement, it cannot be decided. But the Honorable Supreme Court observed that no, it can be decided in subsequent tripartite agreement. It's a civil dispute of civil nature, and it has to be decided by civil court only or commercial court only, and not the arbitrator. In this case also, my lord, subsequently they have entered into an agreement. That para 18, my lord, they have referred that. Whether they can decide it without original agreement. Even in this case, the parties have agreed for some settlement, and he has agreed to pay the amount to me, and I have agreed to go out of the firm. Full and final settlement, my lord. And next judgment, my lord, that Delhi High Court judgment. That is similar to this case, my lord. That ink page 40, my lord.
Page?
Ink page 40, my lord. 40, 40. 40. That para 10, my lord. Para 10. That analysis and conclusion. The settlement agreement is sought to be enforced in the present suit. The said agreement has no arbitration clause. The main plank of the defendant is that the suit is not maintained when the matter ought to have been referred to arbitration in terms of the original contracts. However, the first and foremost feature is that there is no application to Section 8, Arbitration Consent Act, which has been filed by the defendant. The written statement has not been filed and no reply to the IA. Thus, there are no pleadings on behalf of the defendant at all. The court has to decide therefore on the basis of the documents and correspondence on record. And in next para 24 to 25, in that they have discussed a lot in that regarding the facts of the case. And they have referred several judgments, my lord. Para 30, para 30, page number 59.
Para 13.
30, my lord, 30.
Okay. 30.
Page number 59, my lord. Ink page number 59.
Yes.
The above settlement agreement and the email shows that defendant had understood the same to be in complete supersession of the earlier contract. The terminology used by the defendant, final settlement of issues, leave no manner of doubt as to the nature of the agreement. The arbitration clause is not mentioned even once in the said email correspondence. Moreover, effort ought to be made to not unnecessarily linger or protract dispute resolution processes, as alternative dispute resolution mechanism were brought into resolve disputes at a faster pace and not to reopen settled disputes. In addition, the court found it curious that the defendant insists on going to arbitration while not denying the existence of the settlement agreement. Arbitration proceedings are meant to expedite the adjudication of disputes and cannot be used as a fraud to delay the adjudication and escape liabilities and obligations under a duly executed settlement agreement. And in para 33, my lord, next page. The above stated judgment holds that in all cases where there is a subsequent settlement agreement, a valid contract can be extinguished. The settlement agreement in the present case is the subsequent agreement, whose interpretation would show that the arbitration clause in the original agreement would not be enforceable, as this is a full and final settlement with respect to the contract and will be treated as a foreclosed document. The text of the settlement agreement is clear to the effect that this is a final settlement and MOU with respect to the disputes and claims that arose between the parties in consideration to the contract, and that there are pending claims, neither any future claims were permitted to be raised. In para 35, my lord. Currently, there are no claims raised by the plaintiff which arise out of the original contract at all. The only claims are in terms of the settlement agreement which the defendant has acknowledged, implemented, and not refuted. In the present case, there is no doubt left in view of the clauses in the settlement agreement and email that the original contract stood superseded in terms of the settlement agreement. The foreclosure itself is evidence of the fact. In this case also, my lord, the parties have agreed and he never disputed that. I have issued a legal notice. For that, they have not replied. If he has any claim or if he is disputing, if he has disputed that execution of that agreement, you ought to have given a reply to that notice. Even after filing the suit also, in the affidavit, you ought to have mentioned that I am disputing the execution of that agreement itself, or there is a dispute between the parties. Nothing he has mentioned. He simply said that there is an arbitration clause in the agreement, original agreement, so parties have to be referred to the arbitration. There is, the Honorable Court has no jurisdiction. That's what they have mentioned. And the judgment referred by my learned senior advocate is not applicable to this case, my lord. That is Magnum leasing. Because in that case, he has unilaterally cancelled the agreement and filed a suit. In that case, they have said that you can't unilaterally cancel the case and you can't say that once the agreement is cancelled, you can't say that civil court has got jurisdiction and arbitration clause terminates. But in this case, Subsequently, they have entered into an agreement subsequently. Based on that, I filed a suit. In that, he has agreed to pay the amount. In that agreement, it has clearly mentioned that if the first party fails to pay the amount, the second party is at liberty to execute that agreement. Terms of that agreement. Based on that, I filed a suit. My suit is maintainable, and the application filed by the respondent has rightly been, petition has been rightly rejected by the commercial court.
Anything more? Just briefly. Sir, my learned friend is pressing into service the first three decisions are on facts. Nothing will turn much on that. The last decision of the Delhi High Court where he says that the subsequent agreement has extinguished the earlier agreement. In that case, the arbitration clause also fails along with that earlier agreement, which is the correct position of law. What we have to examine here is in the facts of our case, whether the agreement of August 2022 has brought an end to the partnership. If the partnership deed continues to subsist even now, because as we have stated in the subsequent agreement, the partnership partners will exit from the partnership only after the payment is made. This payment is of partnership dues. The second agreement in our case has not brought the first agreement to an end. It has not been superseded. That's why I also talked about novation. There is no supersession. So long as the partnership deed continues to subsist, which is a fact, so long as the amount that has to be paid is part of the partnership relationship arising out of the partnership deed, the arbitration clause will continue to bind us. Because necessarily, my lord, if the decision of the trial court has to be upheld, this court would have to come to a conclusion that the partnership deed has come to an end. This is a new contract and there is a fresh obligation. But if that conclusion cannot be arrived at, then necessarily we have to be relegated to the mode of dispute resolution that we have agreed to in the partnership deed.
That's all. Anything?
If there is any dispute between the parties, then only it has to be referred to the arbitrator for deciding that. Even till today, they are not saying what is that dispute. For the first time now, they are orally saying that there is a dispute regarding that clause. He is referring that clause regarding security deposit. Nowhere they have mentioned earlier. They could have sent a reply to my notice saying that, no, we are disputing that. As per the original agreement, I am entitled to keep that amount for a period of 5 years. Nothing has mentioned because after the agreement, subsequent agreement, that clause has been superseded by the subsequent agreement.
Which clause?
That
Clause 6 of the partnership
clause
deed.
6 of the partnership deed, my lord. That has been superseded by the subsequent agreement between the parties. And subsequent agreement has not been disputed by them.
Just one submission. In case this honorable court is persuaded to come to a conclusion, as my learned friend is urging, that the claim arises out of the subsequent agreement and not the first agreement, then liberty be reserved to the defendant to even question the maintainability of the suit in the commercial court, because it is not a commercial dispute anymore. That liberty may also be reserved.
And they have already filed an application for rejection of plaint.
You will take.
They have
That's
already
right.
filed an application
That's
for rejection of plaint.
In case I'm.
Because they want to protract the proceedings. Now they filed an application under Order 7 Rule 11 that is pending, saying that commercial court has no jurisdiction. They have already filed an application for rejection of plaint
Already filed 711.
in the commercial court. They won't file statement. They want to protract the proceedings. And this is only a suit for merely for recovery of money.
Heard learned. So reserved for judgment.
Great.
Much.
Standard order. What is coming forward for? First, text before. Thank you.
For withdrawal of writ appeal, bill number 107, Mr. Chamraj M.
Figures on record, memo dated 3/8/24, filed by Learned Advocate Mr. M. Chamaraj for the appellant, in which the appellant prays for permission to withdraw the appeal with a view to approach the appropriate forum.
My lords, for serial 107, I am for the appellate.
Withdrawing?
Please, my lord.
Full stop. Any of the memo, the writ appeal is found to be withdrawn, dismissed as withdrawn, full stop. Liberty is reserved to approach the appropriate forum in accordance with law. In respect of it, this court does not express any opinion on merits.
Seal number 109, 109, Srimati Varsha R. Iyengar.
Withdraw. Withdraw. Books. Now, this is about the supplying of books in Braille. The only thing that latest website you may have to find. Because this whatever is given, the figures are given of 21, 22. Latest report is not subsequently.
Then I'll file an affidavit, my lord, bringing to my lord's notice, my lord, what we intend to do, and then.
When the petition came up for consideration, Learned Advocate for the petition was not present. So the present public interest petition concerns the providing of textbook and other reading material to the children who are visually impaired, so that they have the access to the, so that they have free access to free textbooks in the Braille. BRAILLE. While the affidavit and the status report was earlier filed by the respondents, the figures given therein pertain to the academic year 21-22. Full stop. It is necessary that latest developments and the steps taken by the governmental authorities in relation to providing the Braille books to the children with different ability in terms of visual capacity is on record by giving the necessary details in relation to the academic years 2022-23, 2023-24, and 23 and 24-25. That is the current year. All the necessary information related to the subject matter of the public interest petition shall be placed on record as available latest. Full stop. Such affidavit shall be filed within 3 weeks to be listed on 16th December.
Obliged. My lord, serial number 104 may be clubbed along with that.
104 to be
Yes.
listed with.
WP 10875 of 2001. Obliged.
Matter, I appear for KPSC minutes. It's matter pertains to the reservation for the blind. That notification.
Reservation is a different thing. Madam,
For the C&R also, the notification was published, my lord.
don't club it.
Oh, very well.
Please.
This is 108. Mr. Anirudh Anand.
My lord, I was at the stage of reply to the submissions made by the learned government advocate, my lord.
Appearance.
This is of 22. Before 21 amendment, what was the section?
Section 2 for,
No, 8B was introduced in 21.
Yes,
yes.
So before that, what was the position?
it was only 2 years.
Where is that provision?
That
8B,
is prior
8B was,
to
8B was never there.
8B was there. That 8B2 said 2 years. It gets extended in favor of the highest bidder.
That previous section is available.
Previous section, which was my lord amended in March 2000.
Section
That
is-
section I will show. No, we have filed it in the court, no? Gazette notification. The lordship would see the gazette notification at page 53, my lord.
Correct.
This is early. Correct. Yes. Yeah. Page 53, my lord. Annexure B. I have produced the gazette notification itself. My lords have that.
Yes.
Yes.
Ready.
Kindly come to next page, my lord, at 54. The amendment section 8, 5, 8B1. After section 8A of the Principal Act, the following section shall be inserted. 8B1. The provisions of this section shall apply to minerals other than the minerals specified in Part A and B of the first schedule. Notwithstanding anything contained in this Act or any other law for the time being in force, the successful bidder of mining lease expire
Yes, what do you?
Yes, my lord. Page 54, my lords. 8B2. Notwithstanding, may I read? Anything contained in this act or any other law for the time being in force, the successful bidder of mining lease expiring under the provisions of subsection 5 and 6 of section 8A and selected through auction as per the procedure prescribed, provided under this act and the rules made thereunder, shall be deemed to have acquired all valid rights, approvals, clearances, licenses, and the like vested with the previous lessee for a period of 2 years. This, my lord, was the section which existed on 13th March 2020. At page 53, my lord, at the Amendment Act, your lordship will see. This, my lord, was substituted or amended, which your lordship will get it at page, the Act, Amendment Act, at 61, Annexure D. Kindly note the date of this Amendment Act, my lord. 28th March 2021. It has some relevance. 28th March, your lordship gets it. Kindly come down to page 64, my lord.
64.
64. For section 8B of the Principal Act, the following section shall be substituted. I will not trouble your lordship with it. Yes. Notwithstanding anything contained in this act or any other law for the time being in force, all valid rights, approvals, clearances, licenses, and the like granted to a lessee in respect of a mine other than those granted under the provisions of the Atomic Energy Act of 1962 and the rules made thereunder shall continue to be valid even after expiry or termination of lease, and such rights, approvals, clearances, licenses, and the like shall be transferred to and vested subject to the conditions provided under such law in successful bidder of the mining lease selected through auction under this act. Kindly come to next page at 65, 8B2.
$65.
865. I produced the Gazette notification.
Yes.
Necessary, it can be verified from the Act. 8B2. Notwithstanding anything contained in any other law for the time being in force, it shall be lawful for the new lessee to continue mining operations on the land till expiry or termination of mining lease granted to it in which mining operations were being carried out by the previous lessee. My lord, this was in March 2021. Auction was held thereafter in 22. And my mining lease was executed in 22. What the impugned order, my lord, only one sentence, if I can summarize. They have applied the previous 8B and said it is for 2 years. Your lease was executed on 18/4/22. It expires on 17/4/24. Therefore, stop and get the approvals. Contrary to the very, my lord, the amendment, this section itself is not noticed by them in the order impugned. This is only by the Forest Department, my lord. None of the other respondents have disputed this. In fact, the vesting order, the secretary, my lord, mines, and all of them, and I must bring it to your lordship's kind notice, after the amendment made in 20 as well as in 21 to section 8B, MOE of my lord guidelines, they adapted themselves and modified, issued guidelines to be coterminous. Annexure S at 196. Your lordship gets that modified forest guidelines. Page 196, annexure yes, my lord. Page 196, annexure yes. My lord, second para. First, it, my lord, talks of 8B, my lord, insertion as per 28.321, which I read to your lordship, the second amendment. Kindly note the date, my lord. This is 7th July 2021. Annexure S. At 196, my lords have that page. Kindly look at the date, my lord, 7th July 2021. Long prior to the notification calling for auction. Yes, yes. Now, my lord, the first para, if your lordship sees, I am directed to, this is from MOE of my lord, to Additional Chief Secretary Forest, Principal Secretary Forest in all the state governments by the MOE of. I am directed to refer to the Mines and Mineral Development Regulation Amendment Act of 21, which has been notified by the central government on 28.321, where the 2-year period was removed, my lord. Section 8B of the amended act is reproduced below, provided that even after expiry of or termination of lease on such rights, approvals, clearances, licenses, and the like shall be transferred to and vested, subject to the conditions provided under such laws in the successful bidder of the mining lease selected through auction under the said act. It has also been provided in the Amendment Act that it shall be lawful for the new lessee to continue mining operations on the land till expiry or termination of mining lease granted to it in which mining operations were being carried out by the previous lessee. The 2 years has been removed. In the light of the above provisions of the MMRD Amendment Act of 21, the matter related to the validity of the approvals granted under the FC Act was examined in the ministry, and with a view to align with the provisions under the 2 acts, it has been decided that the transfer of approval under FC Act in such mining leases may be considered subject to the following. Therefore, my lord, not only MMRD Act was amended, removing 2 years, even MOEF, my lord, guidelines, they brought it in conformity with the Amendment Act of 2021. Everything that happened in my favor, it is because, my lord, RO Minerals had completed and they were not eligible for any more renewals. Therefore, my lord, it had to be brought under auction, and auction was held, and I was the highest bidder. Lease was executed on 18/4/2022, my lord, for a period of 50 years. If that be so, the law applicable 8B2 after its amendment read with the forest guidelines, my lord. That is the respectful submission. And Annexure N, on a misconception of law that it was only for 2 years, referring to, my lord, unamended 8B, as well as to the forest guidelines of 2020. That is how the impugned communication at Annexure N was issued. 170? Yes. Just have a look at 176 below. Annexure N. Yes. That is the impugned communication below. Yes, 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 yes. May I read with permission of the court? With reference to the, at page 176, Annexure N, impugned order or a communication. What is stated here? With reference to the above cited subject, Messrs. Minera Steel and Power Limited, the lessee or user agency in respect of ML so-and-so, was permitted to carry out mining in 31 hectares of forest land in Kallahalli village, Hosapete Taluk, Vijayanagar district, for a maximum period of 2 years from the date of commencement of the new lease as per clause number 8 of the guidelines. Kindly take, my lord, this into consideration of 2020 guidelines. This is in alignment with unamended 8B, which said only 2 years. Or till stage 2 approval under the provisions of the FC Act is obtained, or till a date that the state government or government of India so decide, whichever is earlier, with all terms and conditions which are stipulated in the forest lease agreement, the working permission was given white so and so. Therefore, you are hereby noticed that the permission granted to you on a temporary basis will expire on 17/4/2024, as the mining lease deed was executed on 18/4/22. You are hereby directed to cease all working in the mining operations, etc. Now, my lord, in addition to this, may I point out 2 things? Number 1, correct me if I am wrong, more than once the learned government advocate said at the bar at the time of arguments that the previous lessee did not have a valid forest clearance because it was granted in 19 and it expired in 2019. But the lease expired in 2021. That is what was the submission made. There are 2 documents which I would like to show to your lordships. Number 1, my lord, kindly take page 143, my lord. Page 140. This is the forest lease agreement, my lord. In this, several things are mentioned. Kindly come to the last paragraph, my lord. At 144.
44.
Last 2 paras permit me to read. Whereas the Government of India MOE of New Delhi, wide number dated 13/5/1999, has accorded approval for forest clearance under the provisions of Section 2 of the FC Act for diversion of 31 hectares of forest land in Kallahalli village, Hosapete Taluka, Ballari district, in favor of RO Minerals, Hospet, for a period of 20 years. Further, Government of Karnataka, wide order dated 17/8/1999, has endorsed the same with certain conditions. Considering the Government of India approval date as the starting date of the forest clearance, the FC for the said mine under the provisions of the FC Act expired on 19. Emphasis was laid on this because their lease was up to 21. So 19 it has expired, therefore you did not have a valid clearance is repeatedly said. See the last paragraph. Whereas the Government of Karnataka, wide GO number dated 19/6/20, in pursuance to the guidelines from MOE of Government of India, has accorded approval for extension of forest clearance for a period coterminous with the period of mining lease in accordance with MMDR Act 2015 up to 22/5/2021. So as on the date of expiry of the lease, there was a valid, my lord, FC clearance in favor of RO Minerals. That inures to my benefit. Not only this, my lord, kindly take.
The auction took place before 22/5/20.
Auction is in 22.
22. All right.
After the Amendment Act, after the FC guidelines.
But they are saying then that clearance expired in 21.
21, it expired. RO Minerals could not get any further renewal because their period of lease with renewals had expired. So under law, it had to be brought out for auction. Then it was auctioned in 22. Lord, lease had expired, FC clearance had expired, the time coterminous. Then when I get it, my lord, under 8B2 in 22, it is not restricted to 2 years. By misquoting a provision of law, this is what they have stated. Lord, when they say that I have a valid FC for 2 years, I can go on with that for only 2 years by quoting, my lord, an unamended, I'm sorry, unamended provisions of MMDR Act. Apart from this, just for a second, kindly see para 6 of their own statement of objection. The very same
On the
document.
date of auction, there was no valid right.
No, that lease had expired.
No.
Forest clearance was not there, Manoj. Valid forest clearance was not there, yes.
Because it expired in 21.
Yes.
It
This is the
expired.
argument.
That is their argument, true, my lord. Contrary to the act itself, for simple reason,
No,
there,
the council is interpreting the word valid rights.
Valid right, yes.
valid as
That's
long as
valid.
RO Minerals had a lease. After its lease is terminated in 21 with an FC clearance up to 21, where is the question of again saying only valid right? Valid right, FC clearance will continue, lease gets executed, lease gets terminated.
Lease was terminated when?
Lease by a flex of time was terminated in 21. At 146, if your lordship would see, second para at 146. After I read that at 144, last two paragraphs, kindly come to 146. May I read at 146, para 2?
Now, subject to the conditions provided under such laws, what is that?
Yes. Forest Act, my lord.
Forest
Forest Act, yes, yes.
Which is section 20?
Section 2.
2, sorry.
At 146.
146. But then you read the clauses from agreement are not relevant.
My lord, the agreement was read, annexure
You read
H page, my lord, it was dated 18/8/2022.
it only narrates the facts, doesn't help you to interpret the.
My lord, it helps. It helps in the sense that there are conditions which says that if they are not adhered to, if my lord takes page 150.
150.
Yes, yes. Condition 5 and 6. 13.
13 years, 13 you
13.
8 also.
8, yes, 8 also. Then page 152.
So forest land schedule has been extended only for mining purpose under the Forest Conservation Act for maximum period of 2 years from the date of commencement of new lease.
Yes.
approval under the provisions of the Forest Act is obtained or till the date, whichever is earlier. All right, we'll consider. Yes.
Now, my lord, if your lordship would kindly see page 140, 146, 146, second para.
146 second para.
My lord, after RO Minerals lease expired in 21, which had a forest clearance up to expiry of the lease. Whereas thereafter, the Government of India has promulgated the Mineral Laws Amendment Act of 20, which inter alia provides that the successful bidder, new lessee of the mining lease expiring under the provisions of subsection 5 and 6 of section 8A of the MMRD Amendment Act shall be deemed to have acquired all valid rights, approvals, clearances, licenses, and the like vested with the previous lessee for a period of 2 years. This is the mistake that they have made, 2 years. My lord, after its period expired, RO Minerals, question of continuing with a valid FC clearance, unthinkable, my lord. I don't know how anybody can think if the RO Minerals lease expired in 21 and FC clearance was made co-terminus up to 21. And it is not entitled for any more renewals because the period granted and renewal to be granted had already expired under the Act. It should be brought out for auction. From the date it expired till the auction is held, where is the question of any valid FC clearance, my lord? When there is no lease at all. Lease has expired. It is because it has expired. It can't be renewed any further. That kind of a lease, property of the government, has got to be, my lord, auctioned. When it is auctioned, whatever the earlier lessee had shall continue. At this stage, 160. May I at this stage bring to your lordship's notice at page 160 annexure K.
K.
Annexure K. My friend was harping on condition 13. This is dated 26/7/22. State level Environment Impact Assessment Authority, Karnataka. Transfer of environmental clearance. Well, all of them get transferred in my favor. Environmental clearance, they themselves have given me a valid clearance, which goes on till the expiry of my lease. It is, my lord, unthinkable, as I said, at the cost of repetition. When somebody's lease expires and it is to be auctioned, where is the question of FC clearance alone being continued? To call it as a valid lease, valid clearance, such a thing does not arise. It's beyond my comprehension, at least. A forest clearance being co-terminus with the mining lease, yes. And when both of them, my lord, are co-terminus and they get expired, and then new lessee comes in,
Environment
they have transferred in my favor.
clearance is given to you till the
Yes, yes.
period of lease.
Yes, 50 years. Under law,
3 years.
under law, I am eligible for 50 years as a fresh lessee. Hmm? 11th page. Vesting order, page 173. Sorry, 73 itself.
My lord,
We'll decide.
yes,
One
yes. My
minute,
lord,
please.
my lord, can I just make a mention? I will not argue. I'll just make a mention. My lord, my lord, while deciding, please refer to paragraph 13 of the writ petition. My lord, there is a query that is put. There is admission at paragraph 15. My lord, there is an admission my lord may take into consideration paragraph 18, paragraph 19, there is an admission. My lord read with annexures S and T.
I'm not
My
mistaken.
lord, then my statement of objections, I'm just making a mention, I'm not doing anything. My lord, paragraph 8. My lord, then paragraph 12, 13. My lord, paragraph 15, 16, 17, and 18.
Perhaps easier to
lord,
say,
and,
except the following paragraphs.
No, it's all right. This is how I've been taught and this is how I will
It's
say.
up to you, right?
Thank you. My lord, annexure S. My lord, page 196. My lord, this answers my lord's query. Annexure S, page 196. My lord, paragraph I. And paragraph 4. That's all, my lord. And I leave it to my lord. My lord, and I'm obliged for my lord's patient hearing.
There are only two documents I thought I'll refer to and close my case. And one para which my learned friend did not refer to in the SO. Page 73. Listing order.
So page 196, paragraph I.
My lord, page 196, paragraph 1
That
and paragraph
1 means complete
Roman.
compliance.
Yes, that will answer my lord.
No, it starts when?
My lord, it starts with, my lord, complete compliance.
Complete compliance.
Yes, that and 4.
It doesn't say anything.
Lord, it says complete compliance of such terms and conditions as stipulated in the approval granted previously under the Forest Conservation Act 1980 and rules and guidelines framed therein in respect of the concerned mining lease has been made. The non-compliance of conditions, if any, stipulated in the approval granted to the erstwhile agency under the Forest Clearance Act 1980, which were required to be complied before handing over the forest land to such agency shall be transferred as liabilities to the new allocatee, and in such case, complete compliance of such conditions shall be made prior to handing over of the forest land to the new allocatee. My lord, those admissions, my lord, are there in my statement of objections.
The paragraph 2, approval under FCA 1980 was valid in the date of expiry of previous.
Yes.
This applies?
Yes, my lord.
My lord, that is page.
Para 2, it was valid till the expiry of
No, my lord,
previous
we
lease.
take that into consideration. I'm not shying away from anything. I'm not shying away.
Let me complete with two more submissions.
Yes.
My lord, and
States
then
it-
my,
Let her complete, yes.
my lord, and then the admissions, my lord gets it, which I have annexed with my statement of objections. My lord, it is annexure R8, then and R9 and R10. And the petitioners have also produced theirs. My lord, at my lord, at P. And compliance report.
Yes. Yes, what?
Yes, my lord. Please see 73 vesting order. Annexure E. This is proceedings,
Page.
page 73, my lord.
Yes. The vesting order.
Vesting order. He is also the nodal officer, secretary MSME, and for all transfers, etc. I'll read only one particular para, government order at 74. Pursuant to the notification dated so and so, and in exercise of the power conferred under 9A2 of the minerals other than atomic and hydrocarbon energy mineral concession amendment rules, I hereby order that all the valid rights, approvals, clearances, license and the like vested with the previous lessee in respect of Oro Minerals are deemed to have vested in favor of the successful bidder, Messrs. Minera Mineral Steels, so and so, on the same terms and conditions of every rights, approvals, clearances, licenses, and the likes, etc. Now take, my lord, para 6 of the statement of objections. So what was submitted is contrary to this. If we are on the same page, is not necessary. Otherwise, for clarification. Typed page 4, para 6, it is submitted that in pursuance of guidelines from the Ministry of Environment, Forest and Climate Change, Government of India, the Government of Karnataka on 19/6/2020 accorded the approval for extension of forest clearance for a period coterminous with the period of mining lease in accordance with the MMRD Act up to 22/5/21 in respect to Oro Minerals. This is an affidavit filed only by the Deputy Conservator. My lord, the head of the department, my lord, is the Principal Secretary, MSME, who is also a nodal officer. In the vesting order, he has categorically said, State Environmental, they have transferred it in my favor. And in the same document, my lord, NPV is also paid. My lord, whatever is liable to be paid, if they give a challan, they have to raise a challan for me to pay. Let them raise a challan tomorrow, within 10 days, I'll pay. There is no difficulty. That has nothing to do with the impugned order.
What you will pay?
If at all there is any difference in NPV, we have paid 2 crores 35 lakhs. If there is a difference, for the first time in the SO, they say another 7.5 crores. Let them raise calculations and a challan. 10 days time, I will pay. There is no difficulty. But that should not come in the way of.
That is not the dispute even.
It is.
Payment of-
There are other violations, my lord, it goes on to 14 crores.
Yeah, tomorrow, if this is taken up, it goes to 18 crores. That's not the idea, my lord, with which it should be done. What is the NPV? There is no law in the country to show what is NPV. It is what the Honorable Supreme Court, my lord, has said in 2 public interest litigation cases, that net present value as on the date. As on the date, they calculated at 75,000 rupees per hectare and demanded 2.35 crores. That was paid. There is a document to that effect. I can show it in 1 minute. Relevant page, if your lordship would see, Annexure H, page 143. 2 crores 35 was demanded through a challan which I have paid. If they still feel, my lord, in the statement they say another 7.5 crores I have to pay, let them just give the calculation and raise a challan against me. But the fact of the matter is that payment, etc., is not a condition for my right to exercise under 8B2. Because all the valid clearances which they had, government of Karnataka through the secretary has already vested in me and given me a clearance, my lord, for environmental also.
That is the issue, madam. That is the issue.
Land is not given. my
Lord,
lord. They
let
don't
her
have
go
the-
one sentence.
My lord, I don't want to say anything. Valid clearance.
We'll decide.
My lord, 1 minute. My lord, that paragraph 6 that was referred to in my statement of objections, my lord will get that in their own forest agreement at page 144, last
Yes.
paragraph.
Yes, that we have
I
read.
don't dispute anything. I don't, this thing.
You've seen that.
There's only one thing which I finally say, my lord. Lord, 2 letters I have written to them. They have made a mistake in understanding the law. It is for 2 years. Because the Department of Mines and Geology said so, I was under a wrong impression it was for 2 years. They refer to an unamended provision. I said, my lord, if that be so, I will do it. And the last thing is annexure T. My lord, if your lordship would see the last annexure, I have even transferred by paying 2 crores and odd, purchased the lands in favor of the forest department, which is accepted. Annexure T. And I, just a moment, my lord, please see that page.
Page.
Annex 198, annexure T.
Yes.
It's not as if I have run away from my responsibility. This sale deed is made. My lord gets at 198. On 21st of November 2023, my lord, the seller's names are given up to serial number 11. Hereinafter referred to as the sellers, which expression so and so, and Forest Department on behalf of the Honorable Governor of Karnataka, represented by Deputy Conservator Forest Second, my lord, I have purchased this property from these 13 people and then 11 people and transferred it in favor of the Forest Department. All that is to be done is a mutation. That is not in my hand. It's a revenue department which has to mutate. Under the revenue laws of the state, the moment there is a sale deed, I need not even bring to his notice, it is his bounden duty to mutate in favor of the person who has purchased under a registered sale deed. And all these things, my lord, not a single word is mentioned in Annexure N. And I started my submissions with Mohinder Singh Gill's case, para 8. Nothing is mentioned. You can't go on improving stage by stage, day by day, my lord. They say it is not like wine in the old bottle going on improving every day. That is exactly the words, my lord, the Honorable Supreme Court used in Mohinder Singh Gill's case. Therefore, my lord, my humble submission is Annexure N does not stand to any reason contrary to law, liable to be set aside. I am grateful to you, lordship.
My lord, last but not the least, my lord, page 158. My lord, the working permission may be seen, my lord. That is all that we are asking from them. Annexure J, page 158. My lord, paragraph 1. My lord, the last sentence, page 158. My lord gets it? Just before 2, my lord, paragraph 2. If the lessee does not obtain necessary approvals.
That is under the old law. That is under the old law 8.
Very well, that was given to them on 24/8/2022.
You are a mighty government. You threaten us to stop, find all kinds of objections.
We'll consider.
Obliged, my lord.
Hola.
Grateful to you.
So heard learned senior advocate Mr. T.L.N. Rao, assisted by learned advocate and learned additional government advocate Srimati Inlo Farakpar. At length. Learned counsel for the party stated that they argued the petition finally, full stop. The stated that the pleadings are completed and no further are required to be added or supplemented, full stop, paragraph. Reserved for judgment.
Obliged.
List number 2. Seal number 2, Mr. S. Shivprasad. Shivprasad.
The complaints affidavit not furnished.
The respondent.
They have to furnish copy of the affidavit.
So endorsement is already issued. That was the only direction. Yes. So yesterday on 15/11/20. On 15/11/24, following order was passed. Then court. Yes. Today when the petition came up for consideration, learned advocate Mr. So and so. But the petitioner was present. Yes. He could not dispute the factum of issuance of endorsement, deciding the representation. Also, in that view, the contempt proceeding does not survive. And if the petitioner has any grievance about the merits of the endorsement of the order, liberty is reserved for the petitioner to institute appropriate independent proceedings to challenge the same. However, this court does not express anything on merits in that regard. The petition is accordingly disposed.
This is number 3, Mr. Sharath S. Gowda.
Lords, I appear for the complainant, my lords.
Hmm.
My lords, the order of which disobedience is alleged, your lordship will get at page 25, my lords. The operative portion of the order. Annexure A, page 25 is the operative portion of the order.
Yes.
My lords, page 25, your lordship got it, my lords. My lords, the direction is twofold, my lords. One, it is to issue modified order. Two, to extend benefits. My lords, there is only partial compliance. Now, by way of endorsement and affidavit, they have issued a modified order, but there is nothing to show that, my lords, they have dispersed the retired benefits. Last 4 lines, my lords. Accordingly, the respondent number 3 is directed to reissue the modified orders in terms of the judgment referred to above, extending the similar benefits to the petitioners in the present writ petition within a period of 3 months. Now they have issued a modified order after filing of contempt, but there is there is nothing on record to show that they have extended benefits. Order is twofold.
Yes.
We have passed the corrigendum orders, my lords. If my lord sees annexure R1.
Yes, it only says that they have issued modified order. They have issued a modified order, but that is only partial compliance. There is no extension of benefits.
My lords, the direction was to reissue the modified orders in terms of the judgments referred to the above extended similar benefits to the petitioner. The benefit is, my lords, which earlier arrears of salary and expenditure, which was told not to be given, is said to be given. My lords, if
yes,
my lords
that I have to get it. It can't be a paper decree. What I will do with the paper, unless I get the benefits?
Where is the main order?
My lords will get it in page 25, my lords. Page 25.
No.
My lords,
Originum is issued, but where is the main order?
original, my lords, we have not placed, my lords, I'll place it on record. This is the copy of the modified order, my lords.
Oh, where is the original?
Original, I'll place it on record.
Tomorrow?
Please,
Tomorrow.
day after, my lords.
Day after.
Day after.
Day after tomorrow, 2:30, second. We can take care by directing that the benefits will be paid.
Yes, they have to give us the benefits, my lords. If they give me benefits, I have to get the benefits.
We'll find out.
Clearly technical, my lords, I'll verify whether.
But if they just modify the order and keep it on paper, my lords, that is not going to serve the purpose. The intention, letter and spirit of the court order was that I will get the benefits. They should say something, yes, they are dispersing the benefits. If that is the case, then
Yes, letter is there, we'll add to.
Last 4/11/23 only we have placed the order.
correct, that only order they have placed. Where is the document to show that they have given the benefits?
Yes, next.
Number 4.
Day after tomorrow, my lords.
Day after.
Grateful.
Number 4, Mr. Naveen Jain.
Tomorrow second. Tomorrow, day after. Tomorrow will not be possible. Day after tomorrow.
Number 5.
But affidavit has been filed, my lord, by the government, and an endorsement is also issued. But though my lord, it is not a full compliance, however, my lord, since in view of the fact that endorsement has been issued, but the matter could be closed. And granting a liberty, my lord, to the petitioner to challenge the endorsement.
Learned advocate for the petitioner, Mr. So could not dispute the effectum of endorsement. To further submit that in view of the endorsement, the contempt petition may not survive. However, we requested the court to reserve liberty for the petitioner to challenge the endorsement. Full stop. In view of the endorsement, the direction of learned single judge to decide the representation is complied with. Therefore, the contempt would not survive. At the same time, liberty is reserved for the petitioner to institute independent proceedings.
Highly obliged.
Not satisfied with the merits of the endorsement, in respect of which, however, this court does not express any opinion on merits.
Number 6, Mr.
Closed of recording.
Balraj JC, number 6.
Here for the complainant, my lords. Compliance of
Para
has
three,
been filed. Liberty may be granted, my lords, to challenge the same.
Learned advocate for the petition stated that the directions under the directions in the order are complied with, as the endorsement is issued, deciding the representation. Also, the contempt petition is disposed of. Paragraph. Liberty is reserved for the petitioner to institute independent proceedings if the petitioner is inclined to challenge the endorsement on merits. So this court, however, does not express any opinion on merits in that regard.
So, number 7, Mr. K. Sridhar.
7, day after tomorrow, man.
Day after tomorrow.
Number 8, Narendra Babu.
Liberty to challenge the endorsement.
Same order.
Para 6, my lord. Compliance has been.
Same order.
Number 9, Mr. Sadanand.
For the complainants, your lordships, stages for await notice report. Notice to the respondents. Await notice to the respondents.
BMRD is contesting, my lords. Both 9 and 10 are the same orders which are questioned. 10 has been withdrawn for compliance. 8 is also the same order.
Same order.
Place, my lord, same order. 9 and 10 are same orders.
Short accommodation may be provided.
Day after tomorrow.
Day after tomorrow.
10 is disposed. Still number 11, Mr. Sagar Bibi. Still number 11.
Compliance affidavit is filed.
Day after tomorrow.
Needful has been done.
Day after tomorrow.
Still number 12, Mr. Satish K.
The accused minute,
Number
compliance
two.
affidavit has been filed, minute,
So
order
that
has been complied.
Endorsement has been issued, my lord, so liberty may be reserved.
Learned advocate, Mr. So-and-so, who the respondent stated that the compliance evidence is filed and post of learned advocate for the petitioner, Mr. So-and-so, did not dispute factum that the endorsement is issued in compliance with the issued to carry out the directions of learned. In the above view, the factum proceeding does not survive, it is disposed of accordingly. However, liberty is reserved for the petitioner to challenge the endorsement of the order. If the petitioner is not satisfied with the merits of the order, by instituting independent process, appropriate independent process. This court does not express an opinion on merits thereof.
Number 13, Mr. Abu Bakar.
13 appear for the complainant, my lord. Here, my lord, the order of the single judge has not been complied with, my lord. They have filed some of the document which has to be translated into English, my lord. That's in Kannada. That they have shown that they are trying to comply, but the illegal construction, whatever erected against my house, has not been demolished. Till I am
Mysore
suffering,
City
my lord.
Corporation is contesting, my lord.
Not yet complied fully, my lord.
Where is the direction to demolish? There is no direction to demolish.
The direction to consider my representation, my lord. Representation, in the representation, I explained, my lord. That has to be considered. And they have initiated the procedures. Now they have furnished some of the documents of initiation that has to be translated for the perusal of this honorable court.
Operation 1, Gaurav GK is the counsel.
Day after tomorrow.
They have filed complaints.
Day after
Number 14, Mr. Kiran J.
340. My lord, the order of the learned single judge, my lord, is at page 13. My lord, the revenue entries has not been changed, my lord, and then the order of the 79 A and B passed by the assistant commissioner. My lord, that has been set aside and remanded for a fresh inquiry. My lord, that has not been done, my lord. The operative portion, my lord, is at page 13. Paragraph 6, my lord. Consequently, the impugned order is hereby quashed and set aside. The matter is remitted back for the first respondent assistant commissioner to consider the case of the petitioner, including the consequences of subsequent amendment brought to the provisions of the 17 A and B of the Karnataka Land Reforms Act. The petitioner shall appear before the first respondent on 23rd February 2022. My lord, we have appeared, my lord, and we have, that is the annexure A, my lord, at page 15. We have appeared and give our representation, my lord. And then, my lord, the further direction is, my lord, to change the revenue entries altered pursuant to the impugned order dated 25/7. This has not been complied, my lord, from past 1 year.
What is not done?
Affidavit will be filed.
What is the affidavit? What you have stated in affidavit?
That has not been served upon. The affidavit has to be filed.
What you have stated in the affidavit?
My lord, affidavit has to be filed yet, my lord, not yet filed, my lord.
Yet to be filed.
The compliance has been done, that's the instruction, my lord.
Alleges contempt in respect of the following direction issued by a single judge in his order dated 3rd February 22. Then quote from page 13, paragraph 6 and 7.
And 8 also, my lord.
8, 6, 7, 8. Full stop. A bare reading of the aforesaid directions go to show that though the directions are issued, no time limit is indicated for the compliance.
Please.
In absence of any time limit, paragraph. It cannot be said at this stage that any of the respondents have committed any contempt, much less willful contempt, to exercise the contempt jurisdiction by the court. In that view, the contempt petition is misconceived. Paragraph. At the same time, the order of the court should not go uncomplied with. Full stop. It is provided while dismissing the contempt proceeding, contempt petition, that the directions indicated in the aforesaid order shall be complied with by the competent authority within 8 weeks from today, failing which the respondents shall be exposed to the aggravated form of contempt.
Grateful.
This is number 15, Mr. Madhav Balaji.
For the complaint, my lord. Complaint has been correct.
filed, my lords. Para 3, annexure R.
Learned advocate Mrs. So-and-so.
Liberty may be given.
Petition stated that the directions of order of learned single judge is complied with. Learned additional Advocate General Ms. Pratima Onnapura confirms the compliance paragraph. In the above view, nothing survives in the present petition. It is disposed of accordingly. Has not survived. Yes.
This is seal number 16.
My lords,
Mr.
in
VC Bond.
16, my lords, I'm appearing for respondent accused, my lords. I filed a compliance memo, my lords. I need to file my this thing, my lord, translated copy, my lords. I prefer week's accommodation.
Please, my lord. No
Please
objection.
complain.
No, complied with or not? We have objection.
It's compliant, my lord. My
Complied with. Learned advocate Mr. So-and-so stated that the order under contempt is complied with. Full stop. The compliance is confirmed by learned advocate Ms. So-and-so, who appeared on online to submit that she has filed compliance affidavit. Paragraph. In the aforesaid view, nothing survives in the contempt petition. Is disposed of accordingly as not survived. So 17, 16, yes.
Seal number 17.
Compliance affidavit filed.
But I
Sagar.
for the complaint.
Like,
My lord, it's partially, my lord, it's not fully complied, my lord. They have not paid any compensation, my lord. As per my lord, annexure A1, my lord, they have on the city municipal council only issued a letter to the, my lord, deputy commissioner, my lord, that there is existence of road, my lord, but my lord, now, my lord, they are saying that, my lord, as per the convenience of the parties, my lord, we have only left the road, my lord. So, my lord,
encroachment is found.
There was a direction to conduct inspection and give a report, my lord. The report has been filed. If you have any grievance, you have to challenge the report, my lord. We say that no, there is no encroachment and no
About-
compensation is what we say.
About the compensation, you decided anything?
In page 14 of the report, my lords, as along with the affidavit. My lords, the first line, and in view of any encroachment not being done and hence it is submitted before your good self that neither from city municipality nor from the government the matter of giving any compensation is not seen. So if they have any grievance, they have to question.
14 of compliance.
Please, does the report.
Where you are reading?
The translated copy of the report. Annexure R1, my lords will get in link page 41 of the affidavit dated 25th September 24.
But where is that page? 14.
14, my lords. 14 is the operative portion.
Yes.
My lords, and the first line may read, my lords, and in view of any encroachment not being done, and hence it is submitted. And hence it is submitted before your good self that neither from city municipality nor from the government the matter of giving any compensation is not seen. Municipality has not encroached any property is the report. They have to question this report, my lord. Court says if there was any encroachment, you have to give compensation. Joint survey, spot merger, everything is.
The writ petition was disposed of by learned single judge as per his order, judgment and order, dated 6th September 21, with a direction to the Director, Municipal Administration, Deputy Commissioner, Ramnagara, and the City Municipal Council, Chandanapatna, to conduct an inspection of the property of the petitioners, to ascertain the factual aspect of the encroachment on the property of the petitioner, and to consider grant of compensation if the determination is in favor of the petitioner. Full stop. The contempt petition was filed. Notice was issued. Pursuant to notice, the respondent filed compliance affidavit producing the endorsement of the order dated 13/9/24. Full stop. And the said endorsement following is concluded after inspection and examination of facts. Page 13 of while examining says across the property. In above view, the conclusion arrived at by the inspection team is that there was no encroachment on the property of the petitioner, therefore question of considering grant of compensation did not arise. Full stop. Nothing survives in the present contempt petition.
My lord, kindly liberty may be given to challenge the report. my lord.
Cause of recording. Full stop. Petitioner is not precluded from independently, from instituting independent, appropriate independent proceedings to challenge the endorsement on merits, if so advised. However, this court does not express any opinion on the merits of such recourse.
Obliged. Bill number 18. Complaints affidavit has been filed.
All day
Para
after-
5 minutes.
Paper complaint. Copy has not been served, Malad.
Complied with
Complied with.
day
Okay.
after tomorrow.
Kindly have it on day after
Rest of
tomorrow.
them day after.
Lordships, one submission. One serial number 28 in the daily list in the morning.
Copy is on-
Seems we have filed caveats, my lord. Caveat has been registered, e-court show the caveat. Despite that, the cause list has not shown the caveat. Matter today at the afternoon at about 4 o'clock, the meeting was held for that to conduct the inquiry in the proceedings in the temple matter. This honorable court, my lord, they have obtained an interim order saying that not to precipitate the matter. My lord, the caveat was put up, not put up, the list was there. It may be taken up tomorrow or day after, we'll make submissions. The name should be shown as per the caveat, madam. The caveat was not put up at all. It was not fair on the part of the other side. Made a mention that there is a caveat. They have served copy also. Caveat was registered and the office could have shown our name. That also is not done.
What order we have passed?
Interim order not to precipitate the matter. Not this some old matter concerning the parties between the list in the regard to temple. That LR application was also allowed. He has brought on record. No hardship will have been.
Where is the other side?
Mr. Abhinav,
If he is here, then we can post it at 11.
I'll inform him.
But today was the matter was there in the, before the deputy commissioner.
Yes, that's why we appeared there and there we came to know that it is interim order is granted.
So
That
nothing to
interim
do-
order granted is
Gov-
that the direction to the government not to
Government-
precipitate the matter,
We have
not on
directed
the,
government not to take any
Precipitative
in
action.
view of the fact that the matter was pending today.
correct.
Manad, as far as the matter technically is concerned, there is a caveat registered, please, Manad. They could have at least shown the name in the office.
What-
At the last minute, the office has suppressed that my name, the caveat.
What happened to that proceeding?
Proceedings, I need to take.
They
an-
could not go on because they have give hand delivery of order. They have informed the committee that there is an interim order passed.
Interim order is signed? How
Not
can
yet,
we-
but they have informed that there is an interim order.
That is a
Immediately, they have contacted the advocate on record and asked him to find out what has happened. Therefore,
Come
we
with the
moved.
other side tomorrow at 11. We'll hear
It
you.
may be listed day after tomorrow, my lord, day after tomorrow.
No, you tell what is happening in that proceedings. Otherwise, we will not list it day after.
No, no, they have stalled the process.
That was,
Don't know.
that is what our undertaking was, my lord, not to precipitate the proceedings.
They have
So
not
that the
held the
deputy
meeting.
commissioner doesn't pass an order till
Tell
such
what
time,
happened to the proceedings before the deputy?
I will apprise you.
Adjourned.
Adjourned.
As per instructions, adjourned.
When it is adjourned?
6th of December.
6th of
6th of December.
December. Come tomorrow or
Day after tomorrow, day after,
day after tomorrow.
day after tomorrow. It may be listed day after.
Which is the matter?
Serial number 28. First list.
First list.
First list, my lord. Thanks.
We have not issued, no, we have not issued notice. All that come day after may not difficult. 028. This appeal was taken up in the first half of the day for hearing. Learned advocate for the petitioner made submissions. Full stop. Learned additional government advocate, Mr. Harish was present. Full stop. In course of the submission, it was pointed out inter-alia that the proceedings were pending before Deputy Commissioner.
Deputy Commissioner.
And that they were posted today. Full stop. Full stop. Having heard learned counsels for the parties, and in view of the fact that the proceedings were pending, and the authority was stated to be insistive, as per the statement of what the proceedings were pending, the court directed learned additional government advocate to ensure that no precipitative action is taken. Full stop. Paragraph. Before the aforesaid order could be signed, at 5:10 PM, when the court was to rise, learned advocate Mr. So-and-so appeared to submit on behalf of respondent number four that they had filed caveat, but the caveat was not shown by the office inadvertently. Full stop. He requested that the opportunity may be given to make submissions by the caveator. Full stop. Learned advocate for the petitioner is not present. Full stop. It was given out by learned additional government advocate and confirmed by the learned advocate Mr. So-and-so for the caveator that the proceedings before the Deputy Commissioner have adjourned to 6th of December. Full stop. Since the caveat was filed, and the caveator and the caveat was filed but not shown, and the caveator is had no opportunity to hearing, let the appeal be posted on 21st November at 11. Full stop. Learned advocate for the learned additional government advocate as a learned advocate for the caveator shall inform learned advocate petitioner to remain present on that.
Serial number
32, seal number 32, the matter kindly we had on Monday, my lords, and led by senior counsel, have informed the other side as well. Pressing for a stay, my lords. Seal number 32, my lords. It would stop at 31 today, my lords. 32, could it please be taken up on Monday, my lords, I'm praying. I've informed the other side they're here as well, my lords.
What is it about?
I'm sorry. My lords, we are requesting for a stay of the arbitral award, my lords. Execution proceedings are pending. Mr. KG Raghavan had appeared on the previous day. Due to paucity of time, it couldn't be completed. Today,
It was what, same matter? It was started?
Yes, my lord. Submissions were started, but because
Monday.
other side, Monday, please, my lord. Will kindly be had on Monday. I am led by senior.
Monday is what date? 25th.
Serial number 63, my lords.
Fifth time it is not reaching. Actually, BBMP have agreed to, instead of alternate decisions, they are ready to pay the compensation. We are also ready for that. So to 2:30 minutes fixed, my lord. Any start date, 74 first list.
In that matter, it was shown. It was not shown. We took up.
Serial
number 22, memo of withdrawal.
Fourth time, it's not coming. 2:30 may be a short time. Again, but why it means BBMP have agreed to, instead of alternate, they say they wanted to give compensation to the site. They've already taken, it is already over. So I'm,
So you want compensation?
I will give one compensation.
Monday?
Oh, yeah.
Monday?
Monday, yes. 230, my lord, 230.
Serial number 22, my lord, memo of withdrawal, my lord. Serial number 22, memo of withdrawal.
52 in board 2.
List 2. List 2,
List 2.
list 2, serial number 22.
Learned advocate, Mr. So and so, files memo dated so and so.
And you know, serial number, list 180.
Memo dated 19/11/24. Setting as under.
81 also, my lord, serial number 81.
1 second. In view of the memo, permission to withdraw. The
Liberty may resort.
is granted.
81.
Mr. is withdrawn.
Serial number 81.
Serial number 63, my lords.
81.
81 also, my lord,
Same.
memo of withdrawal.
Same.
List 1, serial 81.
Same order. Both the memo and 81. Same date.
Lord, please.
57, the public interest litigation pertaining to compulsory imposition of Kannada language on CBSE and ICSE students. Matter has not reached asked by operators. First, a date and time be fixed, members. 2:30 PM at the date. Lot of students are suffering academically because it's been enforced on students who don't know Kannada as their native tongue. Already relief has been granted by this court to degree students. Only the TBC and students are suffering.
Lords,
What date may be fixed, madam?
We'll see. Not urgent. 13th December.
No, I filed an IA for early hearing.
So IA is disposed of. This is an IA for fixing the early date of hearing of the petition.
State may be directed to file objections, they have to file objections.
The petition may be listed for hearing on 16th December.
State may be directed to file objections.
On that day, we'll direct. Today it is not listed.
Serial number 35 and 36, my lord. It may be kept in this week at your lordship's convenience. We are seeking for the stay of the arbitral award, my lord. There's slight urgency, my lord.
Lords, serial numbers.
My lord.
The state has filed one affidavit saying they cannot find movable properties. I'll say submit my reply saying lots of movable properties and immovable properties are available. Over 170 crores is due to home buyers.
Lords,
Date may kindly be fixed, my lord. Serial number.
Date will be given by the learned court officer.
My lord, serial number 101, my lord.
Serial number 6.
No shorter.
Serial number 101, my lord. Tender matter, my lord.
17th December. No date before 17th.
My lord, serial
My lord.
number 53, my lord. The only one small thing, 248 order was asked for BBMP, which I have already attached in page number 18 of my petition annexure.
Serial number
53 of list 1.
53. It was heard earlier. Monday.
It's already attached,
Monday.
My lord, serial number 101 of
Monday.
list 1, my lord. It's a tender matter, my lord. Tender is being finalized this week, my lord.